Appeal dismissed.
Please, Your Lordship. Lordship, I beg to mention a matter for as per your Lordship's convenience. The matter pertains to, my Lord, prosecution of PhD degree without permission. Similar matters have been disposed by this Honorable Court, my Lord.
When do you want?
I'll leave it to your Lordship's convenience, my Lord. First, preferably, my Lord, by next week if it is convenient for this court. But I'm grateful, my Lord. I'm grateful.
On Friday. When do you want? Friday. Friday.
Lordship, I'm praying for a listing of the matter, Lordship, regarding family pension matter. Lordship, first week of September. First week of September. And Lord, may I pray?
Number 30. Other side consultation. 30. 30. I won't be happy. Sir, Alamgir. Attorney Counsel. Do you inform the respondent number 6 and 7? Consent taken. Consent. That's it. Let's go. This is the matter. After? After? 2 weeks. 2 weeks.
Lord, may I pray for the listing of a writ petition for motion on Friday if it is not inconvenient at all?
Friday.
The urgency is that we are seeking promotion to grade 3 posts, and the posts have been advertised and they are sought to be filled up by the government. If they are filled up, then third party rights will be critical. Otherwise,
But that day, your matter may not be. Already, a lot of matter.
then on Monday, then, your Lordship.
Monday is holiday.
Oh, Monday is a holiday. Very well, your Lordship.
There is a similar prayer for listing of a writ petition, my Lord.
When?
There's some urgency, my Lord, that have been terminated without notice. And
When do we want?
my Lord, Friday, my Lord, kindly, my Lord.
Friday.
I'll try, my Lord, if it reaches, my Lord. So the matter would become instructed, otherwise I wouldn't have insisted otherwise. Friday, kindly, my Lord.
Okay.
I'm very grateful, my Lord.
May I please, Lord? My Lord, I am praying for my listing, my Lord, for admission column, my Lord, and 27th, my Lord. 27th
Admission
of this month.
for first week of September. Take it from. Yes.
Oh, bless.
Item number 6 for 12. For the petition.
6. Your name, please?
Yes, yes.
Yes. Internet product payment. Substance is an instruction to your trade is accordingly allowed. It's the within person substance is put upon good right. Liberty? Not required. Yeah.
Lordship, I beg to mention an urgent IA, Lordship, wherein a so cause notice has been issued, where there is a stay order by this Honorable Court, Your Lordship. So there is an urgency. Can it be listed tomorrow, Your Lordship? Highly obliged, Lordship.
Item 43, my lord. In this case, my lord, order complied, my lord. Item 43.
Become an infraction.
Yes, already complied with.
Sir, RSO, Learned Council Board of Education. The contemptor has already complied with the order. And as such, the matter become infraction. And accordingly, the matter is not closed.
I'm for Restaurant 1, Lordship.
Okay. Sir, 64.
Oblige, Your Lordship.
Wait, please. I beg to mention for listing first week of September, madam.
Lordship, I beg to mention item number 22, Lordship. We have to file an IA because for striking of the names of the petitioners.
Item number 22.
Yes, your Lordship.
Where to be listed?
First week of September, Lordship.
First week of September.
Yes.
The prayer being made by Miss
K. Bhattacharya.
Learned Council appearing on behalf of Mr. C.N. Sahib. Learned Council. Matter is scheduled to be listed after 2 weeks.
Yes, your Lordship.
Item number 24. It will be listed on 5th of September, Lord. For the respondent number 8.
You inform the other side?
We have already informed the other side.
Mr. Your good name?
T. Deka, respondent number 8.
The data learned council appearing for the respondent number 8 with the other side response the matter after tweak.
May please, your Lordship, I want to mention regarding listing of to read petition on 5th of September, Lordship, for admission.
I think item number 47. Already died. I want to put that. Legal back.
Item number 40,
Yes.
47. What is your prayer?
I want to file a substitution of legal help. Before time. Petition already died.
47 is IN civil number 2052 of 2025. Is it? Your good name, please?
P. Mohan.
It's P. Also learned for the applicant. Submits that. It may be granted 1 week time,
For it.
4 weeks time. To implement the legal heirs of the petition. Here is according to law. But here the applicant is internal committee of the Yes Bank. Okay.
May I please, your lordship? Lordship, I beg to mention item number 31 for adjournment. Can it be listed after 2 weeks?
31
31.
after.
After 2 weeks, my lord. Engaged counsel has gone out of the station, my lord.
But the prayer being made by Mr.
MP Chaudhary, Manas Wedding
Learned
Chaudhary.
Council appearing on behalf of Ms. N. Secretary.
And second,
The matter is that adjourned to be listed after
2 weeks, my lord. Okay.
Yes. Petition for admission. That
May I be Lordship, this matter for motion, Lordship. May it be on 27th, Lordship,
27.
9. Howland.
How many matter?
similar matter, my lord. Open matters, similar. Similar matter. My lord, similar matter.
Like how many matter?
I think 7 matter.
7 matter.
Similar matter.
Take it for me. Yes.
May please, Lordship, item number 17, Lordship. We have filed an affidavit in reply, Lordship. A record may be called for, Lordship.
Oh, wait.
Item number 17. Affidavit.
May it please, your lordship. Lordship, in regard to item number 54. Matter may be adjourned for a day, my lord.
Your good name?
MZ Rahman. 54.
FZ.
Rahman.
You are appearing on behalf of
Petitioner.
54.
54.
Friends of listening the matter. For adjournment of the matter for the day. There is a for the day. All the matters connected matter.
Yes. Bless you, Lord.
May I please, your Lordship, my lord, I seek adjournment in this matter, my lord, because my lord, the instruction which received, I have received, my lord, from my client, my lord. The authority is, my lord, contemner before your Lordship, is doing the needful, my lord. That's all. For processing,
Okay.
yes.
Then
3 weeks time, may I kindly
3
be
weeks time.
3 weeks time.
It's the day you passport learning. Friends for listening the matter after 3 weeks. There is according to the law.
Highly obliged.
Yeah, Lords. My contempt petition not complying with this order of the Honorable Lord Court dated my lord. Because there are certain directions given by this Honorable Court in a complete judgment, my lord. The page judgment starts from page 11 and operative page 56, my lord. Page 56, paragraph 33, my lord.
It's a test here. It's a big it. There are is inferred by applicant. Occur effect. So not comply. Judgment and order was 5 Austin W or was 5 8 2 6 of 2023 was by this order. Where is the meaning something the documents like the judgment and order date 1/5/2025. This was notice to the contempt part returnable in 4 weeks be taken by registered books with KD and also by legal losses with from the debt. List after 4 weeks.
My lord.
Milord, one item, Milord, item 47. Somebody has mentioned Milord, but she's not in the party, Milord.
Wrongly.
Wrongly mentioned.
Sorry.
Yes.
No, that's wrongly mentioned. I have mentioned item number 45.
47, I am appearing.
Sorry.
It's to learn council for the petitioner price for listing the matter after
4 weeks.
4 weeks.
May I please your lordship? Lordship, the matter here pertains to non-declaration of result regarding the post of junior assistant. Lordship, the petitioner here being one of the candidate, Lordship, there was an earlier direction to declare the result if there were no anomalies found in the selection process. Now, my lord, there is also a contempt petition regarding the same order of this honorable court. During pendency of the contempt petition, the respondents have come up with a letter regarding re-advertisement for the said post again. So, Lordship, that was put to challenge in this present writ petition. Now, my lord, when the matter was listed for before this honorable court, they have come up again with an order regarding rejection of the selection process. So, Lordship, the honorable court was pleased to issue status quo till then. Now, Lordship, this order maybe needs to be challenged, Lordship. I have to communicate with the petitioners, Lordship. It was given to us on last week, Lordship. On Thursday, we have received the affidavit. They have brought into record. So Lordship may grant me some time, Lordship.
State local learn council for the petition. Price for granting her some time. So, you will challenge the order in this petition.
This is not put into challenge, Lordship. Another letter we have put to challenge.
Okay. Price for listing the matter after
2 weeks, Lordship.
after 2 weeks. Okay.
Lordship, till then, status quo may be maintained.
Till
Lordship.
then, there is order
Oh, yeah,
concerted
status
and
quo. Much, Lordship.
Item number 4, my lord. No senior is objection. Kindly fix a date.
Senior is absent.
Out of station. Out of station.
Out of state. As read for by Miss, your good name.
Bonus Sharma.
Learn council for the petition. This the matter after 1 week.
And in this case, writ petition, writ appeal is pending, my lord. That case, it was listed on Monday, no? Monday, my lord. So notice me go and take this matter along with the writ appeal, my lord, 171/2028. I have mentioned in my part.
নহয় rules and rules নহয় হেৰি দিয়ক এই pension regarding pension হৈছে মোৰ বাকী বিলাক হৈছে ন হৈছে and it is listed for hearing in the month of September मतलब September ठीक से है
Only difficulty is I am not sure, Lordship. This is a matter before the honorable single judge and VTPL is before honorable division.
yes मतलब similarly situated person
Matter, Lordship.
no this is a case of similarly situated person I have filed because RTPL is pending as soon as RTPL is result is out then my case will be covered my lord that is why I approached this honorable court and several cases have been my lord your lordship last time occasion you pass an order lordship on Monday as তুমি আসলে যে RTPL
Whether that can be issued, I am not sure, Lordship. We have decision for the honorable single judge and that is before the honorable division bench. Whether it will be. Let this
Let
matter
us
remain.
one thing, adjourn the matter.
Yes.
yes but after vacation the lordship can be fixed
Secretary learned advocate to both.
you fix করেছে vacation
The matter
10টা মান
immediately after reopening of the petition.
Obliged.
highly obliged
May I please, your worship? My lord, here, my lord, the petitioner was initially appointed in the year 2001 as a lecturer. And subsequently, his service has been, my lord, regularized in the year 2018. Now, while the, my lord, process was going on, my lord, suddenly, my lord, the university has issued a notification saying that the petitioner's degree, wherefrom she has obtained the, my lord, PhD degree, has not the, my lord, approval of the UGC. By virtue of that notification, my lord, his, my lord, PhD degree has been, my lord, declared invalid. That has been challenged before this honorable court. Now, lordship, kindly see page, my lord, 104, the important speaking office memorandum, my lord. Page 104, my lord. Operative part, my lord, last paragraph, my lord. In the second paragraph of the referred public notice, it is hereby clearly stated that 3 universities did not follow the provisions of the UGC PhD regulation and also academic norms for the award of PhD degree. Therefore, due to non-compliance of the UGC PhD regulation and academic norms, the PhD degree awarded from the above 3 universities cannot be accepted by the Higher Education Department, Government of Assam, for any condition withdrawal for regularization, provincialization, upgradation of the service, and for any direct recruitment to the post of principal, assistant professor, librarian, and CSA, promotion, etc. This was issued by the, my lord, Secretary to the Government of Assam. Subsequently, my lord, lordship will find speaking order, page 105. My lord, last paragraph, my lord. Hence, the condition of withdrawal for scaling of the fees structure as per the UGC norms upon acquiring the PhD degree in respect of Dr. So-and-so, he is the petitioner, my lord, assistant professor, so-and-so college, cannot be considered and hence rejected. Moreover, all previous orders, communication number so-and-so, and so-and-so are withdrawn by this department with immediate effect. With this matter of condition withdrawal, proposal is complied and disposed of accordingly. Now, this is the, my lord, speaking order against the, my lord, petitioner. Now, though the, my lord, condition has been laid down in the notification, lordship will find the public notice, lordship will find in pursuance to the, my lord, petitioner's degree has been nullified, my lord. That is at page 100 and page 100, my lord, 100. Page 100, my lord. This is the public notice. Based on the public notice, these 2 important notice has been issued. Page 100, lordship will find below, my lord, last paragraph, my lord. The petitioner got degree, my lord, PhD from Singhania University, Junjunu, Rajasthan. Now, prospective students and the parents are hereby advised not to take admission in the PhD program offered by the above universities from now onwards. In absence of the UGC approval, PhD awarded by the above 3 universities shall not be treated recognized, valid for the purpose of the higher education and employment. Now, this notification cannot be given retrospective effect, since the petitioner has obtained the PhD degree in the year 2016 and they are been exempted. Lordship kindly see on reply to the RTI, another similarly situated person, Lordship will find at page 107. It is respond to the RTI application. Sajjan Kalta, so and so, sir. Recently, you have devoured 3 universities from Rajasthan. In this, you have devoured them for 5 years from PhD degree to 2025 to 30. What will happen to those students whose PhD finalization or viva is due in 2005? Should we consider the hard work of those students of 3 and 4 years wasted? Now, below Lordship will find Monish Joshi. She has given the tweet, new admission shall not be allowed. Those who are already registered can complete their work. Now it says new admission as deferred, but those who have completed the PhD degree prior to that notification, those degree cannot be nullified. Now that too, Lordship will find one clarification letter given by the respondent authorities at page 103, 103. Lordship got it. It says, with reference to the subject cited above, I am directed to enclose here the copy of the letter under reference received from Monish R. Joshi, Secretary, University Grant Commission, Ministry of Education, Home Department, New Delhi, regarding debarring some university for enrolling PhD students for 5 years. In this regard, you are requested to take necessary steps to obtain clarification from the UGC regarding the validity of already awarded PhD degree from the universities, and further also prepare a list of teachers who have been regularized earlier based on the degree obtained from those concerning universities as mentioned in the UGC public notice dated 16/1/2025. Now, this clarification has been sought, but till date, no clarification has been obtained by the department. Without obtaining the clarification, they have nullified my degree.
So, yeah.
Not other people pending in this, I cannot find that. What is the initial purpose?
Let notice be issued and in the meantime the import speaking order, because it cannot be prospective. It cannot be retrospective.
Of 6/6/2005 is not coming now. If Lordship, Indian will consider after returnable that Lordship.
I obtained the degree in the year 2016. They have issued the notification in the year 2025 in the month of January.
Notice that indeed on returnable date, because an other person is pending, but I could not find the third person. Only notice is or otherwise then this time I will be instruction.
Okay.
If the notice is
Heard, Mr. Apongal, heard. That is, we have put a respondent.
1, 2, 4, and 5, Lordship.
1, 2, 4, and 5, and madam, forward.
Respondent number 8, Lordship.
Next, your good name, please. Learned Council, appearing on behalf of Mr. El Samoa, learned Islamic Council, respondent number 8. That's madam, you. Respondent number 8. Respondent number 8. Expedition of Article 6 of the Constitution as select the office memorandum struck executive order dated 22 5/2025 and the speed order dated 6/6/2025 for 2, whereby the PhD degree obtained by the petitioner in the year 2019 from Singhania University, Rajasthan has been declared as invalid. Declares as invalid. Whereas the petition under the record and also part of the office memorandum stroke executive order dated 22/5/2025 and the speaking order dated 6/6/2025. That notice be issued to the response returnable in 4 weeks. The bid taken by registered post with AD and also by usual process. However, no formal notice is given, as they are represented by the This is the matter after 4 weeks. The meantime, Mr. Bhuya shall obtain necessary instruction and advise this court on next step. Please after 4 weeks. Then you
Lord.
obtain instruction thereafter will.
That observation may be given detail on reasonable date.
Consider on next step. Yes.
Yes. Lord, another petition, my lord, with regard to the my lord, same petitioner, my lord, that may be my lord posted, my lord, along with this present, my lord. WPC, my lord, 1094/2025. Yes.
Already pending.
Already pending regarding regularization of his service.
Okay, Mr. Monto submits that concerning similar subject, another application WBC number
1094/2025.
is also pending for this court and which matter may be taken along the. There is according to the allowed rate of 2008.
Developers.
Wait, Mr. Lordship. It's a third round of litigation, Your Lordships. The petitioner was initially appointed way back in 1995 as an assistant Assamese language teachers in a Bengali medium school, which is in the district of Kokrajhar. Thereafter, Your Honor, due to non-inclusion of his service for regularization of a service, the petitioner has moved before this honorable court, praying for provincialization of our services, Your Honor. The Honorable High Court, which I have annexed the order, Annexer I, page 48. There, this honorable court had made certain observation and to direct the provincialization of our services. Page 48. Annexer I. May I read the order, Your Honor? Lordship. On
Thereafter, what happened?
Thereafter, the inspector of schools has forwarded her name for a district scrutiny committee, which is Annexer K, page 54, and a new act has been enacted by the Government of Assam by scrapping the earlier Hampshire School Provincialization Act 2011, whereby Annexer K, page 54, the inspector of school has forwarded her name for the consideration, and her name is placed number 19 at the serial list. Thereafter, the department has filed a review application challenging the Honorable High Court's order. This Honorable Court's High Court order, but that review application has been dismissed on withdrawal, which is Annexer L, page 59.
Thereafter,
There are series of application representation has been made before the concerned authority for regularization of our services, but the no fruitful results have been come out, and moreover the one re-verification has been also been directed by the by the Director of Secondary Education to the Deputy Commissioner, which is Annexure R, page 72. In 2024. And in that re-verification, genuineness of our services, her name has also been included in the list. Only one person for the Kokrajhar district in the year 2024. Despite the continuation of his service from 1995 to 2000 till date, despite getting any single salary, the respondent authority, despite going to the order passed by this honorable court, has not considered his provincialization of his service, despite knowing the fact that this honorable high court has categorically directed to provincialize her service, and she is the only one person in the district.
Then why don't you file a contempt petition?
Because Lordship, the review application has been filed by the state.
That was withdrawn.
But thereafter they have withdrawn their lawsuits.
Yeah.
But the assurance has been given to the concerned department to regularize our service, and there is series of communication has been made.
Why don't you file a contempt petition for non-compliance of the earlier order?
No, Lordship, yes, Lordship, there is not filed, the representative has not filed the contempt application, but the assurance and the representations, they have duly considered their, as per their version, that they will consider her representation and they will provincialize her services as soon as getting the approval from the government of Assam. But till date, series of inquiry has been made regarding the genuineness of service, despite his name has been enlisted for the provincial service. Her name has been tilted when considered for provincialization, despite knowing the fact that she is the only one candidate from the state from the district of Kokrajhar. That is my prayer before this honorable court for consider and regularize her service.
Yes, Mr. Chaudhary.
My lord, here, my lord. Notice may be issued, my lord, here. Because director has considered her name, and it is mentioned in page number 72, Annexure R, my lord. So now the joint committee in its meeting held on so and so has opined that for further proper verification of the claims, they itself be re-verified at the field level by independent authority to ascertain the genuineness of the claim. And my lord, accordingly, page 74. The incumbent whose services is required to be verified at field level. So here, my lord,
Number 50. Her name is
number 50, Kokrajhar. Our name is reflected. So, my lord, in this notice may be issued. In the meantime, I will get the instruction regarding the status of this matter.
Moreover, a similarly situated person already we get the provincial services in page 81. Annexure, I have annexed page 81. One Uttam Sen Balika Vidyalaya is the similarly person has been included in the provincialization.
When this field verification was done?
On 19/2/2024, this communication has been made. 19/2/2024.
Page number 74.
Page number 72.
So what happened there?
In this regard, I have to take instruction. Now it
If
is
you
a
want an
verification
instruction,
process, my
we'll
lord.
take it over 2 o'clock today.
Lodge. Lodge.
The matter may only be taken up in sometime, lordship. I think. Lordship.
May it please, my lord. We are teachers, my lord, assistant teachers, my lord, graduate teachers working in Dhemaji district, my lord, in various schools of Dhemaji district. My lord, may kindly have Annexure 5, page 48, my lord. My lord, as per this notification, our services were notified, my lord, and we were given the benefits of Regular pay scale, my lord. Page 48, my lord.
Hmm.
Notification. Issued by the Additional Secretary to the Government of Assam Secondary Education Department.
Hmm.
My lord, my names appear in serial number 1, 2, and 6. Our names, my lord. 1, Dipen Gogoi. 2, Kuntal Sutia. 6, Hiramoy Honwal.
Hmm.
Serial 1, 2, and 6. This is a notification dated 26/2/21. My lord, my basic grievance in the writ petition, limited prayer, is that similarly situated persons, that is the pro forma respondents 5, 6, and 7, they have got, my lord, they have been, the graduation list has been published, my lord, owing to which they will be promoted to the next post. But whereas we being similarly situated with them, nothing has happened on our part. We have been kept in a state of limbo. If my lord has the page 79, my lord, notification of the pro forma respondents, my lord, page 79 for a moment.
Yeah.
Similar, my lord, 26/2/21 order, my lord. Pro forma respondents, my lord. Serial numbers, my lord. 158, page 85. Serial number 5, page 79. Same page, my lord. Kalpana Gogoi, my lord. Pro forma respondent. Kalpana Gogoi, serial number 5. Then, my lord, page 81. Serial number 67. 67, my lord. Midusmita Sutia. Last one, my lord. 67, Midusmita Sutia. And my lord, page 85, serial number 158. Zugantor Lahan. Similarly situated, my lord. Their services are also notified on 26/2/21. Now, my lord would kindly have the draft graduation list at page 94, my lord has 94. Draft graduation list of graduate teachers. My lord, my basic grievance in the entire case is that this list has not been issued in our case. They are similarly situated, whereas for these pro forma respondents, it has been issued, but for us, it has not been. That is why we are not being promoted to the next post of headmaster. We are still stuck as assistant graduate
Page
teacher.
number, page number.
94, my lord. May I show the serial numbers, my lord? 94. Draft graduation list under, as per Rule 25(2) of the Assam Secondary Education Provincialized Schools Service Rules 2018. This is for, my lord, for teaching staffs, my lord. 25(2) of the said. May I take my lord to the serial numbers, my lord? My lord would have, my lord, serial number 1206 at page 95, my lord. Page 95, my lord. 1206, my lord.
Yes.
Zugantor Lahan, my lord. Zugantor Lahan, 1206, my lord. Serial. Pro forma respondent. Then, my lord, may kindly have page serial number 1246, page 96. 1246, my lord. Next page, 96. Midusmita Sutia. And my lord may at last have serial number 1300, page 97. Kalpana Gogoi. 1300. But I've preferred a representation, my lord, before the said authorities, my lord. That has not been considered till date, my lord. Page 69, 11/7/25 representation, my lord. That may be considered, my lord.
The other day, Mr. Sistri appeared.
My lord, secondary education appears, my lord. Respond. 10.
No, this order you have enclosed,
The last order, that is of that other case, my lord. The pro forma respondents, they have preferred a writ petition that is ongoing, my lord. That is sub judice. That is a different cause of action. I'm just trying to draw the parallel, my lord. That this order, my lord, is not directly connected to the matter, but because I have made certain statements about the pro forma respondent and have implemented them, that is why I have annexed this order as well. There, my lord, their cause of action is different. They have come for protecting of their services, and this honorable court had protected their service by the last
It's another matter.
another matter. That is another, my lord.
Forward to this present petition, Your Lordship.
Midusmita, I am not telling that I want to get my head in with Midusmita case, my lord. I am saying, my lord, we are similarly situated with Midusmita, as our services also were notified on 26/2/21. By that notification,
Your
there's
representation is pending.
yes, my lord. That
for
may be
the birthday.
yes, my lord. 11.
Presentation, yes.
Can
11.
we dispose of this matter by
Your
directing them?
Lordship, directing them to Your
Yes,
Lordship.
my lord. Yes, my lord.
Re-verification
Yes,
and
yes.
examining the proper documents, Your Lordship, if he is entitled.
Day, my lord. Three.
Representation dated 11/7/2025 is that page number?
My lord, 69, my lord.
Page number 69. Okay, then we will dispose of this petition by directing the respondent authorities to dispose of your representation.
My lord, and there was an interim prayer also to issue the draft gradation list in our, that also observation, if it pleases, my lord, that may also be made. I am deeply obliged. Disposal.
Give me your best.
May be lordship. My lord, the petitioner has been appointed as a postgraduate teacher in the subject of economics, my lord. By the order dated 25/5/2023.
Teacher.
Yes, postgraduate teacher, economics.
In
By
which-
order dated by lord, page number 12, order dated 25/5/2023. His name at serial number 5. Page number 12. PGT economics, my lord. And pursuant to that order, my lord, Inspector of Schools at page number 14, my lord, has provided him place of posting at page 14, serial number 4,
Hmm.
at Kaliganj Public HS School.
Yes.
And my lord, accordingly, he has joined in the service, my lord, page number 16, joining report, type copy, on 15/6/2023. Thereafter, what happened, my lord? Suddenly he was got some medical issues, my lord, and could not attend the school, my lords, with effect from 3rd August 2023. And till, my lord, 31/10/2024, he has submitted the regular applications. It starts from page number 18 to 35, my lord. He got some admission in the medical college also, my lord. Annexure 5, the medical documents. And Annexure 6, my lord, is the medical fitness certificate. After recovering from the medical issues, my lord, he has been given the medical fitness certificate on 15/10/2024, page number 43, my lord. Type copy. And thereafter, my lord, he has submitted one representation, 17/10/2024, to the Inspector of Schools, for principal, my lord. Annexure 7, page 45, requesting him to, my lord, to allow him to resume his service. That representation is not yet, my lord, acted upon. To my humble submission,
When did you file this representation?
my lord, it was 17/10/2024, my lord.
till then no action was.
No action has been taken. He hasn't been allowed to, my lord, resume his service. My humble submission is that, my lord, this will be disposed of, my lord, with the direction to the,
Be allowed to obtain instruction. This may go, your lordship.
it will linger the process of joining only. There is nothing,
No, why the representation is pending since 17/10/2012?
Pertaining to that, your lordship, I may allow to obtain instruction.
it may
Okay,
come on,
2 PM today. Offline instruction.
double.
May I please, your lordship? My lord, this matter is relating to compassionate appointment. My lord, father of the petitioner died in the year 2016. Application was filed in that year also. And in the DLC 2017 lordship, rejected the claim of the petitioner on the ground that there was a lack of vacancy.
Pardon?
There was a ground that there was a lack of vacancy. On that ground, DLC rejected in the year 2017. Thereafter, we filed a writ petition before this honorable court, and this honorable court directed to the DLC to take the matter as a fresh and consider. Accordingly, lordship, their name has been recommended by the DLC. Lordship, that is, your lordship will find page 48. This is the DLC meeting on 31/8/2024. And the name of the petitioner, your lordship will find at page 50. Serial number 3. Lordship, but
Serial
Yes.
number?
page 48 is the DLC minute. That is dated 31/8/2024. And page 50, serial number 3, Deepak Kumar Shah. But the lordship, SLC is not taking up the matter on the ground that there is an office memorandum, that is page 52. Whereby decision is taken that no DLC or SLC meeting will be taken because the scheme has been cancelled. Page 52. My lord, there are a series of writ petitions also filed before this honorable court. And this honorable court, lordship, has disposed those writ petition, page 54, directing the DLC or the SLC, as the case may be, to consider without taking into account that notification, because their claim was prior to that. Page, lordship, 59, para 7 is the operative part. At decision part, lordship, page 60, para 9, Roman 2. Similar direction may be given, only limited prayer. The matter is to be placed before the SLC, and SLC should consider it.
Lordship, whether is forwarded, that is placed in the next SL.
Next SLC or lordship, some time frame may be given because they are not intending. No. Some, your lordship may given a.
The council knows very well, and if hundreds and hundreds of applicants are. So they, official, according to they are making the necessary preparation, so, and let it be in the next SLC. So you will
Next
get the equal
SLC, that is okay. But lordship, if your lordship given 3 months time,
We will see.
my lord, item number 13 and 14, same lordship, same DLC has recommended.
13. Okay.
Same DLC has recommended then. Number 1, 2, and 3 is their name.
Okay.
Lordship.
In this matter, my lord, at this stage, I'm just praying for a notice. What has happened is, these people were appointed, these three petitioners, they were appointed as far back after a selection, as far back as in 1996. There was some dispute regarding their, my lord, some confusion regarding their appointments. If your lordship will just have a look at the appointment order, page 45.
Yes.
In fact, my lord, the confusion entirely arose because of this, my lord. If your lordship will first come to page 35. This is the original allotment order. Page 35. my lord.
Yes.
In pursuance of the government letter number so-and-so dated 6/8/91, 15 posts of assistant teacher for middle school in the prescribed scale of pay plus other allowances as admissible under government rules is hereby allotted. And thereafter, my lord, there are serial numbers 1, 2, and 3. And just after that, there is a sentence. These posts are originally created by government letter number so-and-so dated 11/3/77. So since these were two dates, there was a confusion whether our appointments were regular or not. What had happened actually, way back in 1977, 1,000 posts were created under a particular scheme. And out of these 1,000 posts, 38 posts were allotted to Hailakandi. These 15, thereafter your lordship will find page 37, another 8 posts allotted. Then page 39, another 5 posts allotted. So likewise, a total number of 38 posts were allotted to Hailakandi. And against this, at page 45, your lordship will find, this is the petitioner number 1, page 45. Subject to discharge without notice and without assigning any reason thereof, the following empanel candidates being selected by the subdivisional level advisory board for elementary education Hailakandi are hereby appointed temporarily as assistant teacher in middle school as mentioned against each of their names, etc., etc. And your lordship will find Abdul Hussain Laskar. And similarly, the other petitioner is at page 47, identical appointment order, Gayatri Das. And then page 49, your lordship will find the third petitioner, Jayashree Chaudhary. Because of these 2 days, confusions arose. We approached this honorable court. This honorable court referred the matter to an expert committee. Expert committee did not take any final decision. It is an admitted fact that there was a huge fire due to which all the records were burnt. So there are no records available admittedly. However, neither the expert committee again referred it to a screening committee. Again, screening committee also did not take any decision. Now what they have done is this, madam. Page 82 is the order impugned. After rendering decades of service, now they have given us a fresh appointment, wiping out our entire past service. Entire service rendered from 1996 now will be treated as fresh appointees. So at this stage, I am praying for a notice. Let them respond.
Yes, sir. Notice may go, my lord. My lord, for 82 also, my lord, that one point may be taken into consideration, my lord. They have appointment. All these appointments have been given, madam. They have consented to this. Consented to this, madam. Notice may go at this stage. We'll file a consolidated.
Mr. Chaudhary, you have received salary for the service rendered
No, madam.
earlier? No.
That is why the matter was referred to the expert committee. This honorable court, in fact, my lord, if your lordship will kindly come to the order passed, High Court order, at page 57. We approached this honorable court way back in 2011. Page 57 is the order. It starts at page 57. If your lordship will kindly turn to page 60. Towards the middle, there is a paragraph starting the director in the affidavit in opposition.
Yes.
The director in the affidavit in opposition filed in WPC number so-and-so has stated on oath that since the relevant original records documents relating to the appointment of the petitioners as Hindi teachers in the middle schools under Hailakandi district were destroyed in a devastating fire which broke out in the office of the Deputy Inspector of Schools, Hailakandi, on 18 September 99. No record is available and hence it cannot be treated that the petitioners were appointed regularly. This was the only ground on which they were saying that we are not sure whether they were appointed regularly. And therefore, what this Honorable Court did was this one. Be that as it may, since this court in Sudhendu Mohan Talukdar's case has constituted a high-power committee to look into the grievances of the teachers relating to non-payment of salary, the writ petitions are disposed of directing the Commissioner and Secretary Education Department to place the claim of the petitioners before the said committee within 1 month from today. The said committee within 45 days from the date of receipt of the necessary communication from the Commissioner and Secretary shall deliberate on the matter and make necessary recommendation. But this recommendation never came. What the expert committee did is at page 73, madam.
Yes.
This is the minutes at page 73. If your lordship will come to the operative portion at page 75. Towards the bottom, just above the signatures, your lordship will find a decision. After thorough verification and deliberation, the committee has recommended that since it appears that these 37 teachers were appointed irregularly, their cases were referred to the screening committee. We have to obtain findings of the screening committee. Irregularly on what basis? The records are not available. How can you say? Because the appointment order itself clearly says that our appointment was pursuant to a selection. And that appointment order has not been ever disputed. But the expert committee says that irregular and therefore again referred it to some screening committee. Screening committee does not take any decision and now they are given fresh appointments. So entire past service will be wiped out.
Lordship, just one point I want to point out of here, my lord. At this stage, notice may go, but your lordship comes to page 82, your lordship, of the appointment of the petitioner number 1. There, my lord, on the last part, if your lordship sees, from bottom, my lord, the appointee shall also have to furnish undertaking. So at this point, at that point of time, they have given the undertaking, my lord. They have given the undertaking for joining. So they have undertaken and they've joined. So I will, my lord, we will be filing an affidavit, my lord. So at this stage, notice may go, my lord. We'll be filing a consolidated affidavit. Because they have given undertaking and then they have changed.
Undertaking, these people are in such a helpless situation. It is almost like taking a decision at gunpoint.
All the appointment orders. I have challenged that.
Heard Mr. Aishwarya, learned senior counsel assistant minister.
Yes, Mr. Karnataka.
Learned counsel of Mr.
Standing counsel element for education for my lord 1, 2, 3 and 4 men.
1, 3 and 4.
Even this
Five,
5 also.
I think the commission.
5.
And 5 also.
5.
5 also. This is the finance part.
The purpose report 6. Fine. Under Article 226 of the Constitution, order number is number 30. Where the numbers are there. By which the petitioners have been appointed as tutors against personal post at a fixed salary of rupees 10,800 per week. So totally learned counsel for the petitioners that the petitioners were appointed in the year. In which year they were appointed?
1996, man.
In the year
Page 45.
1996. The year 1996. And since then they have rendered service till their appointment by the new orders dated. So, and for the service rendered by them earlier, they have earlier, but the entire service rendered by them are during the period from 1996 till their appointment is wiped out, and they have not paid a single penny.
No, no salary. Initially they had got, but it was stopped, my lord. Just a few months they got.
Initially receiving the salary for few months, for few months. The subsequent officer already learned how to put up in further analysis probably to the however, no further notice is triggered to be issued in over and particularly under evidence and however, extra requisite copy of the pardon and the reports that they covered for the in the meantime, the evidence that we of the respondent authorities file their affidavit in place like this. If you
Right.
Lordship, the matter may kindly be taken out for some time, Lordship. After some time, Lordship, time being obliged.
May it please, my lord. My lord, I was working as a faculty, my lord, at Jagirod College, my lord. Temporary post. My lord would kindly have my appointment order at page 26, my lord. 11/8/2017. Page 26. Contractual faculty at BVOC Retail Management Program. My lord, this is a BVOC program is basically, my lord, a Bachelor of Vocational program, my lord, where vocational skills are taught to the students, my lord. This is a course, my lord, under the UGC, my lord, which had been introduced in various colleges, my lord. 2015 it was floated, my lord. Guidelines also have attached, my lord. Page 28, my lord. Page 28, Annexure 3, my lord. My lord, under this BVOC program, I was in the retail management department.
So page number 26 is the appointment letter.
26 is the appointment letter, my lord, my appointment letter.
Then 27 is the extension order.
Yes, my lord. And 28 is the Annexure 3, my lord, UGC guidelines for BVOC courses. My lord, in the guidelines, may I kindly refer to page 36, my lord?
Now what happened?
Now, my lord, what has happened is that I have been terminated, my lord. My lord, I'll just be very brief, my lord. A rift had occurred in a GB meeting, my lord, in the said college. My lord, what had happened is that the principal of the said college, the Jagirod College, openly had stated that BVOC course, the course I was teaching, it is a dead subject. To which I had given my dissenting opinion, exercising my right under Article 19. And I said that it is not a dead subject and it is important for the students, for their development and skills and everything, for them to get jobs. My lord, because of that, my lord, my termination was given on the same date, 27/6/25. The meeting was conducted where I had given my dissenting opinion. And on the very same date, my lord, to punish me, my lord, on 27/6/25, same date, I was terminated. My termination is at page 56, my lord. My lord, I would like to read the contents of the termination. This is vital for the case, my lord. 56, my lord, has my lord. May I read, my lord?
Yeah.
To Kumar Bikasnath, that is me, release letter. It is known to you that gradual dropping of enrollments in the last 3 years in the BVOC Retail Management Department. The department has been facing financial crisis to pay even monthly salaries to 2 teachers. We are total 2, my lord. Further, due to no students admitted in the last year 2024 to 25 and this year in 2025 to 26, the retail management department has currently only 3 semester appeared students. Due to insufficient students in the self-finance program in retail management, I am sorry to inform you that the college is not in a position to continue 2 faculties in the department for further term. Low enrollment issue and salary related matter was already intimated to you verbally several times. So at present, I have no option other than to terminate you with effect from 30/06/25. Thank you for your association with the retail management department. Now, my lord, this termination letter is itself flawed because, my lord, they have stated here because of low student intake and financial problems that the department doesn't have finances. To that, my lord, would kindly have Annexure 4, page 52, my lord. This is a proposal by the government, my lord, to show that government has put their trust upon the BVOC course and they were in talks to allocate a fund. May I kindly read, my lord, page 52. 20/01/25 dated. There is a proposal, my lord. In order to enhance the provision of skill education and maintain the current Bachelor of Vocational BVOC course in the colleges of Assam, I engaged in a comprehensive discussion with the All Assam BVOC Faculties Association. My lord, the relevant portion is in the bottom portion, my lord. If we decide to provide a basic pay of rupees 57,700 per month for the faculties as per UGC and rupees 20,200 for non-teaching staff, the financial implication will be rupees 6 crore 55 lakhs 3,200 rupees. So, my lord, this proposal was floated by the government itself, my lord. Down is the endorsement. Then, my lord, would kindly have page 53 of 53 for a moment, my lord. This was a meeting conducted, my lord. A meeting was conducted, and my lord, it was sent to all the stakeholders of BVOC courses, President Secretary of All Assam BVOC Faculty Association, and all the other relevant stakeholders. Here, my lord, I would read the relevant portion, my lord. With reference to the subject cited above, I am directed to inform you that a meeting under the chairmanship of Honorable Minister of Education, Assam, has been scheduled to be held on 25/6/25 at 3 p.m. at the conference hall of Honorable Minister of Education, Assam, first floor, regarding the salary status of BVOC faculties in the colleges of Assam. You are therefore requested to make it convenient to kindly attend the said meeting as per the schedule, date, time and venue with relevant documents. My lord, I would also like to take my lord to the UGC guidelines for a moment regarding the disbursement of amount that is given by UGC for these courses. For just for a moment, my lord. Would have page 36. This is the guidelines I had referred to previously. My lord, money is not the issue. Finance is not the issue. The problem. Yes, my lord.
You tell me,
Yes.
what happened after the meeting of with the education minister?
My lord, till now, my lord, the
Whether
said
any amount was sanctioned?
but that is not in our knowledge because that is a proposal. My lord, I am just trying to show the intention of the government, the seriousness with the course.
But that's all right, but there is no enrollment in the year 2025, 24.
No, my lord, there is, my lord. I don't have right now, my lord. Admission is done in the Samart portal. To my humble knowledge, Samart portal online people have to do. The students have to enroll. Here, my lord, in the impugn notice at page 56, they said that there was low intake, my lord. 3 students they had stated, my lord. Whereas in the Samart portal, which is not with us, that is with the principal. There it was shown that 8 students had come to take admission in the for the said course, the retail management course. That is a flawed statement, my lord, by the authorities. My lord, that was passed in a hasty manner on the same date when I had made that statement, when I had dissented with the said authority. In order to punish me, I was terminated. 56, my lord, has for a moment. Here, my lord, it is said that currently only 3 numbers of third semester appeared students. 3 they are saying, but for 25 session, my lord, the new session, 8 students had come. I've made a statement in my repetition to that, but I don't have any document to show. Otherwise, my lord, this is my case, my lord. And one more aspect, my lord. The law related to for temporary employees, my lord, is last come, first go. There is a junior, my lord. We are 2 faculties. The respondent number 6 had joined after me. If there was such a difficulty, my lord, let's say, my lord, if there was actually this financial crisis, low student intake and everything, my junior should have gone. Last come, first go, my lord. There is a Supreme Court judgment. If I may kindly, with the permission of the honorable court, my lord. When in case of retrenchment, my lord, regarding temporary employees, then my lord, the employee who is junior has to go, not the senior. I am the senior most faculty. 2 faculties, I am senior most. I should not have gone. But because of this dispute, this rift with the authority, I had to go. May I kindly submit the judgment, my lord, if it pleases my lord. Para 5 of the judgment, my lord. State of Uttar Pradesh versus Kaushal Kishore Shukla. I've flagged the relevant page, my lord. Para 5. May I read, my lord? Para 5. There is no dispute that the respondent was an ad hoc and temporary employee, and the terms and conditions of his employment were regulated by the UP Temporary Government Servants Termination of Service Rules 75. The contract of service as contained in the appointment letter also stipulated the terms and conditions of the respondent's employment, that his services were liable to be terminated at any time without assigning any reason or compensation. In the counter affidavit filed before the High Court, the order of termination was defended on the ground that respondent's work and conduct were not satisfactory and he was unsuitable for the service. Therefore, his service were terminated. To support that contention, the appellant placed reliance on the adverse entry awarded to the respondent in the year 1977 to 78, and also on the allegations made against him with regard to the audit of Boys Fund of Raja Dagubar Dayal Inter College. The High Court held that since junior persons to the respondent in service were retained, the order of termination was rendered illegal. In our opinion, the principle of last come, first go is applicable to a case where on account of reduction of work or shrinkage of cadre retrenchment takes place, and the services and the employees are terminated on account of retrenchment. In the event of retrenchment, the principle of last come, first go is applicable, under which senior in service is retained while the junior services are terminated. That is the principle, my lord. And they, in the impugned order also at page 56, they have cited the same reason. Financial crisis, my lord. Retrenchment, my lord, due to economic reasons. That the fund is not there. But my lord, fund is, my lord, in fact, if my lord peruses page 36 for a moment, categorically the guidelines say that a huge amount is dispersed for this kind of courses, my lord. If for a moment, my lord has page 36, my lord, just for a moment. Huge amount is given, my lord. It is not like they are facing some economic problems or anything, my lord, financial crisis or anything. My lord, 11 point, my lord. Financial assistance. May I read, my lord? The financial allocation will be made by UGC within overall ceiling rupees 1.85 crores for a period of 3 years under different head as given below. Startup assistant, a one-time startup assistant of assistance of rupees 50 lakhs for setting up laboratories, workshop facilities, procurement of teaching and learning materials, machineries / equipment and renovation. Faculty, 1 associate professor and 2 assistant professors, rupees 75 lakhs, rupees 25 lakhs per annum, rupees 75 lakhs to be reimbursed on actual basis. My lord, these are the various. So, my lord, it is not like the institutions are bereft of fund. Here, my lord, the matter boils to the point that I had a rift with my authority, and that is why I'm suffering. Also, my lord,
Only guidelines, whether this amount of money was disbursed to the colleges.
my lord, that UGC can say, my lord, when the instructions come. Otherwise, my lord, this is a mandate under the guidelines, my lord, that this amount is given, my lord, since it is there in the guidelines.
Yes.
And this course has been running.
Oh, yeah, you are appearing for?
For higher education for one lordship, for higher education lordship, one and two lordship.
My lord, 2 months salary also not given, for which I have worked, my lord.
Yes.
Page, my lord, 57, 58, my lord. And yes, my lord, 57, 58, my lord. For 2 months, my lord. My lord, may kindly have. My lord, for the months of June 24 and February 25, my lord. That may kindly be allowed, my lord, in the interim. I made a prayer to that effect. In my representation also I have stated, page 62, otherwise.
Lordship is a, what I find lordship that this is scheme by UGC lordship, fund provided by UGC, direct to college lordship. And the appointment or contested appointment issued by the principal of the college lordship. Notice may be issued lordship, and then we have to instruction, and UGC is have to say the fund is there or not.
Notice may,
Only notice.
notice may go, my lord, in my interim prayer, salary for 2
returnable
months.
date. That will
No, my lord, prayer for 2 months, my lord. That is my right, my lord. I worked for that period.
the principal not before now.
My lord, if they refute, they may not give. If my lord allows the interim, my lord, just 2 months, my lord, hardly 31,000 rupees.
But
If I am wrong, my lord, they may not give me. They'll file a reply anyway.
Without-
Notice will be
also, hearing the
my lord for 2 months, my lord, June 2024 and February 2025. That will be somewhere around 31,000. Just 2 months, my lord. Around 31,000, because last I was drawing 15,000.
after notice lordship.
No, my lord, just
hearing the principal lordship.
No, my lord.
The principal is the main authority lordship.
My lord,
So in the
principal will
address,
file their
I
reply.
don't know,
Principal
nothing to
will
say.
file their reply, my lord. At right now, my lord, I'm entitled to the money I have
Without
worked for,
hearing
the wages, my lord.
college authority lordship.
It's my fundamental right, my lord. I've worked for
Short
the period.
notice.
Notice may go, my lord.
He
As
can,
my senior,
he can-
respected senior is,
the-
notice may go, but interim
He
period
can
will be
only
considered.
service dossier also to the principal lordship.
My lord, illegality is patent, my lord. My junior is
That will-
retained.
That will overcome.
I have been thrown out, my lord. In spite of the settled law, my lord. Last come, first go.
It is, it's a June, month of June lordship. Order
They
is
are
month
not
of June.
clear, that is why I've asked.
Order is month of June lordship.
Yeah, pardon. That takes from 3 order.
It's for 1 and 2 lordship.
That's number 1. 1 and 2. Is there? For PG con for responding number 4. That's number.
What university? Vice principal?
That's number 4. Is there?
R. Guya on behalf of Mr. A. Sombal for the UDC.
Yeah, pardon. We have. It's not card. That's number 3.
Yes, sir.
That's number 3. It's a sort of product also product extra service that the customer was appointed. His first appointment.
My first
was
appointment dated, my
11/8,
lord,
2017.
11/8/2017.
The customer was appointed on 11/8/2017. Yes. Contractual faculty. And he of get retail management program in Zagreb. And thereafter, he has been re-engaged as contractual faculty at the retail management program by order dated 1/9/2017. That he has been rendering service in the Zagreb College till the date of his termination on 27/6/2025. So Sharma further submits that the petitioner was terminated from service by order dated 27/6/2025 on account of financial crisis to the college and also due to no students admitted in the last year 2024-2025 and in the year 2025 and 2026 in the retail management department. And currently only 3 numbers of third semester. 3 numbers of third semester appear students. And due to insufficient student and self-finance program in retail management, the college is not in position to complete two activities of the department for further term and thereby release the. Mr. Sharma further submits that the petitioner is the senior most faculty and in view of the decision of Honorable Supreme Court in the case of State of Uttar Pradesh and another versus also Kisurla reported in 1991. What essence 691. 691. The petitioner, being the senior most, would not have been deserved as the principle of last come score is applicable in case where on account of reduction of work or simply the career retrenchment takes place and the service of employees are terminated on account of it. Then further Mr. Sormel said he has not been, the petitioner has not been paid salary for the month of
June 24 and February 25, my lord.
February 5. Such circumstances considered Sharma has attempted to interfere with the termination order dated so and also to issue and in the interim also to direct the principal Zagiru College. Respondent number.
My lord, respondent number, my lord.
5.
5, my lord.
Number 5 to release the salary of the aforementioned 2 months. The submission of Mr. Sharma learned counsel for the petitioner and further consideration that his success notice be issued to the respondent returnable in 4 weeks. However, no formal notice is required to be issued to the respondent. Since they are represented by their engaged company. However, extra requisite copy of the petition will furnished to them during the course of the day. Notice upon respondent number 5, 6, and 7. Be taken by registered post with daily and also by usual process to working days from today. Thus, this service is also permitted. And after effecting service of the council for the petitioner will find an affidavit before this court. Is the matter after 2 weeks?
Yes, ma'am. My lord, interim may kindly be considered.
The respondent number 5 directly to release the pending salary of the petitioner. For salary of the petitioner for the month of
June 24 and February 25.
this after 4 weeks.
I am deeply obliged, my lord.
Will the resume after 5 minutes?
Okay.
Lordship, matter regarding Lordship, the provincial Lordship. So last proposition Lordship, so Honorable Court please to direct it the respondent elementary department Lordship to file a scanned copy of the Annex 2 Lordship. And so few minutes ago, my esteemed colleague informed me they have filed one affidavit Lordship. So that affidavit has not been recorded Lordship. Did not furnish Lordship. So finally, we filed affidavit lordship. So
Yeah.
that part has been provided. Affidavit. Yeah.
Yes.
Elementary document.
So subsequently, Lordship has directed to file another affidavit, my lord. But we have filed on 10th of April, my lord. File করেছো?
Recent one.
না না 10th of April
আচ্ছা।
এখানে না এখনো বেশি আরো ফাইল
এইটো এফিডেভিট আছে নে
তাৰপিছত সাবসিকুয়েন্টলি ফাইল কৰিব গৈছিল
নাই নাই সেই বস্তু আনি পৰিছিল পেজ 27 আছে তেতিয়া আছে
27 to
কি তাৰিখ বাকিছে
order also actually during the
Affidavit file on
10th April, my lord, 2025, my lord. 10th April 2025, my lord.
So that affidavit available with me, lordship. So
Lordship, kindly see page 37. man. What was sought for was this particular annexure enclosures at page 37, Lordship may see. It is letter dated 2014.
Lordship,
Lordship will see some enclosures are there, my lord, down below. These documents are sought for because these particular documents were sought for by this honorable court from the elementary education department.
Yeah.
Because the block elementary education officer, he said that in 9 and 10, the dice data of the petitioner was there. But our, my lord, so far as my lord, SSA is concerned, we have filed the affidavit stating that, my lord, in 9-10, there was no such, my lord, dice record of the petitioner institution.
Lordship, sorry for interruption, Lordship. So
This has not been placed.
So Lordship, the last question, Honorable, please to direct it to furnish one scan copy of the annexure 2, Lordship, of the writ petition, Lordship. And that part has not been furnished, Lordship.
Annexure 2.
It's not take most probably, Lordship.
Annexure 2.
Annexure 2, Lordship, of the writ petition, Lordship, most probably. So last question, annexure 1, 2, and 3, Lordship. Scan copy. Help us,
Annexure 2.
Lordship,
one and
proper my-
annexure 1 and 2.
1 and 3 has submitted, Lordship. Sorry, 1 and 3. 2 has not been submitted, Lordship. So from my point.
Annexure 2.
Annexure 2, Lordship.
District Information System of Education. Dice capture, data capture format.
Most
This one is, my lord, annexure 2.
Some coupon appeared. 6/8/25.
On the last occasion, my lord had asked us to file an affidavit regarding the information, my lord. But already there are 2 affidavits filed, my lord, on this particular point, my lord. And so the second affidavit which was filed by my lord, colleague, my lord.
No,
Senior
there is
colleague?
no direction for.
So my lord, what had happened was, my lord, the
Direction was to only produce the enclosure number 1 and 2.
Yes, Lordship.
Then you try for granting 1 week time. We have granted the time to you.
my lord, 2 is over here only. 2 is over here in the affidavit which has been filed by my colleague. my lord. Kindly come to page. The dice data. Will come to page 198 of the affidavit in opposition filed by my learned friend on 10th of April.
Page number 1.
198. This is the 198, my lord. This is the dice data. Dice data chart, my lord. 9 to 10 and 13 to 14, my lord. That thing has been annexed, my lord. It has been annexed in this particular affidavit. The dice data has been furnished, my lord. And your lordship had asked us if your lordship sees the affidavit which learned friend has filed at page 2
page 2 of the affidavit. There, my lord, of the said affidavit, there it has been given that the deponent begs to state that, or by order dated 13/2/25, this honorable court was pleased to direct to furnish instructions in respect of issuance of annexure 6 dated 13/12/13/2 to 14 at page 37 of the writ petition, as on the basis of, on what basis the VEO Dhekiyajuli had issued the same. So that is the thing. The data is there, my lord. It's been given here. Okay.
Where is this enclosure number 2?
Yes.
Inspection report?
Two, my lord, must have not been there, my lord. But the other one is there, my lord. The DIAS data is there. The DIAS data is there. It's already annexed. Already two affidavits were filed, my lord. One has been filed, my lord, one has been filed on April 10th of April 25. The other one has been filed on 16 December 24. 16 December 24.
The book on this data from page number 190.
And
part of the affidavit filed by the director of secretary.
Elementary education. And my lord, at page 20, at page 1 minute. At page his name is not there. Only W Huck, his name is there, my lord. Petitioner's name is not there. In DIAS data, petitioner's name is there only from at page 206, my lord.
Mr. Pupar,
At 11/12.
the case of the petitioner rests upon this enclosure. What is this enclosure?
My lord.
They mainly relied upon this. The DIAS format of the 9, 10.
9 and 10. So 9 and 10 is not there. 9 and 10, his name is not there. 9 and 10, his name is not there. If your lordship sees 9 and 10, his school name is not there. Some other person, W Huck.
No, that DIAS data copy is furnished by Mr. Gogoi. We are asking you to produce the enclosures of this letter dated 13/2/2014.
Yes, Lordship.
This DIAS format.
Which one issued by the BO, Lordship, page 37 of.
Then, my lord, I need some time accommodation, my lord, because this thing has not been sent, my lord. Because no, my lord, the last time we had written to the directorate. So this is the data from the, actually, my lord, block elementary education officer. So we had written to the directorate, not the BEO. So directorate has given the same thing which has been given in the affidavit. And that's why we did not file the affidavit, my lord, again. Now, my lord, I'll seek instructions from the BEO, because this letter which your lordship has cited at page 37 of annexure 6, it has been given by the office of the block elementary education. So I'll have to get the instructions from him. Perhaps that is why they have not given me the correct information, because the information which I have got is the same information as the affidavit filed by my learned friend, which is already filed. So that is why we did not file the affidavit. We thought that we'll go proceed with the current affidavit. So therefore, my lord will give me another, my lord, 10 days time. I will contact the BEO and I will ask him for the enclosures 1, 2, and 3 of page 37 of the writ petition. And actually, if it is, my lordship allows, my lord, because that will be required for the proper adjudication of the case, man.
So, directed to producer say filed order dated 9/6/2025.
Yes, Lordship, exactly.
Several opportunities were afforded.
Last chance will be given, my lord. I have given, my lord, but I have given the directorate wrongly, my lord.
First it does, pardon. It's a it may be granted 110 days time to obtain necessary the block 11 PD education officer. देखिए देखिए in respect of enrollment number 1 of the letter dated where is according to account. Fifth of September.
Deeply alleged. Mass alleged. Lordship, apart from this case, Lordship, so I have gone through the legends of justice book, Lordship. So if permit, Lordship very much appreciate the legends of justice book I have gone through, Lordship. So there consists one of the Chief Justice, Lordship, the Bernard Peacock. He stated, Lordship, if permit, Lordship very much appreciate, Lordship. Only one sentence, Lordship. He says, Lordship, an unflinching advocate of the freedom of the peace, and that such believer is the main bulwark right of the people, Lordship. And he was very perseverant and vindicated, Lordship. So Bernard Peacock, he was the first Chief Justice of the High Court of India.
That's given to
Yes. Mass alleged.
Yes.
This is regarding overstay in service, Lordship. You have filed an affidavit in reply on today itself, Lordship, and record was called for.
The letter I said,
So the date may be fixed, my lord, for hearing because this reply has been received by me today only, my lord. I have to go through, let it, date be fixed, my lord, for hearing.
third is the forward Bernard for the petition. Mr. Das Bernard
I'll be,
higher part fish.
I'll be appearing for 1 and 2, my lord.
I'm appearing for 3 and 4.
1 and 2.
1 and 2 and the third.
I am appearing for 3 and 4.
Let's put that number 3 and 4. Theory is there.
Yes.
No, Your Lordship, not yet.
Okay. The Das Bernard something council for the respondent in higher education department submits that he has received the reply filed by the commissioner today only, and he plays with granting some time to go to the safer. There is about receipt of the letter after 1 night.
I'm praying for a date.
Obliged.
Much alone.
I can 18 and 19.
I'm for 7 and 8, my lord. That's one of us.
May I please, your lordship? My lord, there is a 2 order had been, my lord, passed by this honorable court, my lord, for the purpose of release of my salary. My lord, only 3 months salary had been paid, my lord. And a proposal, my lord, had been sent on 18/7/2025 by the district elementary to the director, my lord, for the purpose of other part of the arrear salary. And this has also been submitted by my learned friend on the education department on the last time also, my lord. So, my lord, the order of this honorable court has not yet been fully complied with, my lord. Only a part had been
The
complied.
amount of the payment which was there is it is in process of being paid, my lord. The current, I think, salaries have been given.
No, only 3 months salary
It's
has
been
been
given, my
paid.
lord. And on the last occasion, if your lordship remembers, is in the treasury office, the previous wrong, my lord, this thing was there and that was corrected. That was why it took time. So it, my lord, takes time. That is why, my lord, some time may be given. Perhaps he was not there on the last occasion. My friend, his junior was there, my lord. Wherein we had his treasury head was wrong.
Oh, wow.
That was placed last time. So that took time, but ultimately his 3 months salary was given, man. The other thing also is in process, man. So some time may be given, man, in this matter, man. That is what the department has instructed me, my lord, to convey in the court that we are in the process, we are processing everything.
My lord, on behalf of Pressman number 7 and 8,
I like to submit, my lord. My lord, your lordship.
Lordship, one more thing. One more thing I have instruction is that the creation of the NPS in respect of Shoriful, my lord, also has been, my lord, with all supporting documents have been submitted to the Sub Treasury Office, Vilasipara. And the area salary proposal for the period, my lord, also has been delivered. So the NPS thing also has been, my lord, is in process. The NPS, that is also a factor which will be taken into consideration, should be taken into consideration.
So in respect of my respect number 7 and 8, I like to submit before your lordship that respect number 7 was appointed as science teacher in the year 1991. 18 years junior to the writ petitioner, 18 years. And respect number 8 was appointed in the year 1994, 14 years junior to the writ petitioners. But here, the chaos and cloud has come on the order that coup that there are 2 posts. As per guideline, my lord, education guideline teachers pattern, my lord, it says that there are 2 teachers, assistant teachers, 2 assistant teachers and 1 science teacher. Now, as per record reveals that, my lord, the respondent number 7 was appointed in 1991 as science teacher. My lord, kindly have a look at page 85 of my learned friend writ petition. Page 68, 85. Yes, page 85. Page 85 of my learned friend writ petition. This honorable court order dated 28/1/2020. My lord, kindly have a look at page 85. My lord, paragraph 9. Your lordship order in WPS 6530/2016, the claim between Kurban Ali, that is respondent number 7, Kurban Ali and Shariful Islam, that is the writ petitioner, is in respect of the post of science teacher. It is contacted on behalf of Kurban Ali that is entitled to do the aforesaid post of science teacher, as he had been appointed as a science teacher in the year 1991. That is almost 18 years earlier than Shariful Islam, that is the present writ petitioner. However, the school authorities as well as the state authorities have provincialized the service of Shariful Islam by ignoring this fact. My lord, next paragraph, paragraph 10. It has been, however, submitted on behalf of Shariful Islam that the factual position as submitted on behalf of Kurban Ali is not correct, since Kurban Ali was initially appointed as an assistant teacher, and in fact, his appointment was approved by the District Elementary Education Officer, DEO in short, in the year 1995, which was never put to challenge by him. Therefore, the fact remains that though Kurban Ali was appointed as an assistant teacher in the year 1991 by the school managing committee, his appointment was approved by the district authorities only in the year 1995. My lord, next paragraph, paragraph 11. On the other hand, it is also the case of Kurban Ali that there are documents to show that he was actually appointed by the school managing committee as a science teacher, and he joined as a science teacher on 27/1991. Response number 7 joined. Annexure 1 of WPC number 852/2016. And also his appointment as a science teacher is approved by the DEO Dubli by order dated 21/2/1995 in Annexure 2 of WPC number so. So his service for science teacher was approved by the District Elementary Education Officer Dubli, my lord, on 27/1991, 21/2/1995. So he was already a science teacher. Response number 7 has been approved as science teacher. So only 1 science teacher is required. How writ petitioner has come as a science teacher, second teacher, and how his service has been permitted and how he's got salary, God knows. He is sitting in the sky and I am sitting in the land. What is the difference on that? My lord, kindly have a look at page 87, paragraph 14, next page. Page 14, paragraph 14, my lord, is 87. Accordingly, this court, without making any observation on the claims and counterclaims of the respective parties as regards the genuineness of their appointment orders issued by the school managing committee, as well as the approval orders issued by the state authority, directs the commissioner and secretary to the Government of Assam Education Elementary Department to re-examine the respective claims of the aforesaid three teachers and pass appropriate order after hearing all the parties, taking into considerations all parameters, including seniority, as provided under the rules as regards their entitlement of the post claimed by them and also their claim for provincialization. So seniority was to be, should look into, the Honorable Court said. My lord, very pathetic matter is this. You should have a look at page, my lord, page 73. My learned friend has annexed in his writ petition, page 73 of this writ petition, page 73. Page 73, my lord. Annexion 19, my learned had annexed. My lord, paragraph 4, page 19, annexion 19, page 73, paragraph 4. No provincialization order will be affected in case of schools having any court case in connection of appointment of teachers, dispute on land, absence of dice code up to 2009-10, and conformity with the provisions, the Assam Venture Education Institution Provincial Service Act 2011, amended up to 2012. So the order of the government says that no provincialization order will be affected in case of schools having any court case in counter appointment. So there are 3-4 cases are pending. Since 3-4 cases are pending before this honorable court, how my writ petitioner has got his service provincialized, but his order, government order says no provincialization. So my lord, the appointment of writ petitioner is in dispute, and there are cases, lot of cases are pending, and matter is sub judice. So he has got his service provincialized and getting salary.
Affidavit in opposition here.
My lord,
You have filed your affidavit in opposition.
I have filed, my lord. I have filed. Of course, only on this day I am appearing before your lordship, but they have handed over me all documents. They have filed the affidavits, my junior, in earlier cases. I two affidavits filed, my lord. One affidavit is filed by the respondent number 7, my lord. I think in your lordship records is available. And another affidavit has been filed by the respondent number 8 also, my lord. So, my lord.
Sir, Bhuya, whether the matter is ready for hearing.
My lord.
This matter is ready for hearing.
My lord, it can be heard. Only thing, my lord, the department has not yet filed any affidavit till date, my lord, because we are challenging an order of the, my lord, director. So therefore, their stand is required, my lord, by of an affidavit. Or if
Yes,
they,
Mr.
my
Bhagwan, where is your affidavit?
तो अपने लोगों से 7 and 8 affidavit file करें. The husband number 7 and 8. 7 and 8, pulmonally 7 and 8.
Because, my lord, the speaking order dated 25th of May 2022, page
number 7.
102 of my writ petition is basically under challenge, my lord, wherein we are praying for a certiorari for setting aside the same, my lord. My lord, my learned senior friend is repeatedly submitting, my lord, that how and in what manner we are receiving the salary, my lord. He is not agreed with the order passed by this honorable court, my lord, directing us to pay the salary. Until and unless those orders are, my lord, governing the field, my lord, the authorities are duty bound to pay the salary, my lord. That's the today's position and contempt petition, and my lordship is constantly monitoring regarding the, my lord, earlier 2 orders, and wherein, my lord, this honorable court has specifically directed that our salary should be paid, my lord. So that's why, my lord, the matter has at least come to a conclusion that at least 3 months salary has been paid and the rest we are expecting, my lord.
Rest is in process, my lord. It is in process. Last time, my lord, in the first occasion, my lord, the treasury, this thing was in the wrong, I had given the, my lord, instruction. wrong treasury, my lord, not Bilasipara, then it was corrected to Bilasipara. Then after that takes time, my lord. So that the documents for the NPS,
You know, whether the correction was made.
yes, that was correction has been made.
Correction
because
is made, my
that is
lord,
why
as
he got
per
the
our
money. That is
instruction.
why he got the money. Otherwise, the money would not, he would have not got the money. Then the money, the
No,
3 months
when
money he
the,
got.
when
and
the
then
arrear amount will be paid.
that will take some time, my lord.
Why?
Because that, my lord, I have to take instructions plus I have to, with the finance department automatically. So some time may be given, madam, because otherwise the thing money, 3 months money has been given and the documents for NPS not listed, madam, that I have submitted on the last occasion. That has been also submitted to the sub treasury office, Bilasipara. That was submitted late because of their wrong mistake, not because of us, madam. Because of their wrong, my lord, business head was fixed, madam, then that was corrected. It takes time, my lord. Some time may be given.
So my only submission before your lordship is this. The read petitioner is 18 years junior to me. I am a science teacher. My service has been approved by the District Elementary Education Dubli in the year 1995.
At the time of final hearing, we will consider your.
So my only submission, my lord, your lordship will consider, but he is pressing for salary. And I am cutting the grass of the horse. I am not getting anything. I am going to be retired
My lord,
very soon, my lord, old
My lord,
person.
what has happened, my lord, it is on due to their fault, the order which we are impugned. They are also required to challenge the same, my lord. Till date, they are sitting silent without challenging the very impugned order. Their services has not yet been provincialized and it had been directed that under the 2017 acts, myself and along with my respected senior friends, 2 clients are directed to be provincialized. Otherwise, my lord, I was provincialized in the year under the 2011 Act. Now, my lord, when this honorable court prima facie considered at the very motion stage, my original provincialization order has not yet been disturbed by anybody. On the strength of my original provincialization order, my lord, I had been directed to pay the salary, my lord. That is the factual and legal position at this moment today, my lord.
My lord, what about me?
No,
What about 7 and 8? We are rendering our service.
my lord,
We are on the verge of retirement. Last 24 years. One is working as now 35 years. Another is 31 years, my lord. Nothing. We have got single penny. We have got single penny. And my friend is enjoying salary.
No, it is my
How
right,
pathetic-
my lord.
how
It is
pathetic
my
scenario
right.
is
I am
this, my lord?
enjoying. I am not taking his part, my lord. I am not taking money from his pocket. It is the government paying me. Now, if my senior friend is also entitled, he will be paid accordingly, my lord. I am not taking his money, my lord.
So, my lord,
So, my lord can finally hear and dispose of, my lord. The affidavit from the department is required, and in the meantime, my lord, my arrear salary should be paid within a time-bound period, my lord. That's
My lord,
the my
the
lord.
administrative part, then time bound period, that may be kept on the loop, my lord, because it is in process, my lord.
Already,
things
my lord,
take
there
time,
is
my
a
lord.
there
These
is a
things take
direction,
time.
my lord.
When you are going to file your affidavit.
Regarding the main case, my lord, that is 5620, my lord, that we'll get, I was not in this matter, I was in the contempt, I'm in the contempt case, my lord. But in this matter, my lord, we'll file an affidavit if required, my lord. But the main case we are on is the contempt case, my lord, and the contempt case, my lord, it is in process. 3 months salary he has himself is admitted, he has got. And because of that time, my lord, that Bilasipara treasury, my lord, was not in Bilasipara treasury. Because of that, there was a obstacle. Some form, my lord, will fix it after 4 weeks.
You file your affidavit in the
Main case, my lord. And my lord, fix it after 4 weeks. 4 weeks.
That's necessary.
Mr. HR Khan for 7 and 8.
Number 7 and 8.
7 and 8.
Elementary
Education department.
Mr. Bhuya, Garden the respondent in elementary education department has not yet filed their affidavit to adjudicate the issue being raised in this petition. Affidavit of the respondent in elementary education department is very discussed. According to Mr. Bhuya, submits that something founded for the respondent in elementary department directed to file their affidavit in. Accordingly, it is provided that the open garden council for the respondent in elementary department shall file affidavit on or before
In September. My lord, one, I have prayed that I have got no salary kindly. And I'm praying for my compensation of service and salary, my lord. That may be record.
That year is not in this petition.
This is my petition, my prayer, my lord. My friend can file a separate also.
Yes,
You can file a separate claim.
concept petition, take down current stuff. We are learned something for the stuff for the concept one. The matter is being processed by the respondent authorities for payment of immediate salary of the people. And the price for granting in supply to comply with the order of this court. There is accordingly allowed, place the matter on.
Lordship, instead of 15, can it be a little later, my lord, on the end of September? 27 September.
No.
Or 22nd.
December lo illa. My lord.
Deeply obliged.
Highly obliged.
Highly obliged.
Lordship, kindly pass over for timing. BTC is the main party here. We are forming. Sonaram. Yeah.
Lordship, on behalf of Mr. M.H. Ahmed, the judgment we are going to rely upon is under review. So it's been reflected on the earlier order also.
Can you sit?
That's at least by Lord and advocate for the party, this is a matter. After discussion.
Deeply obliged. Enjoy.
My lord, in this case also, my lord, till date, no any affidavit has yet been.
May it pleases you, Lordship. Affidavit has sent for vetting, Your Lordship. Kindly grant us 1 week time to file it, Your Lordship. Already affidavit is sent for vetting. 23 another course.
Hard for Mr. AR, yeah, but I think the court of. And also hard. Yeah, but that. This one.
No, Gada. MD Mohammed Ali, last page to Kiman number.
After 1 week.
My lord.
Yes, sir. Deeply obliged.
My lord, may I pray for a fixed date, my lord? My lord.
Deeply obliged.
Obliged. my lord.
My lord, in this case, my lord, my prayer is twofold, my lord. One, my lord, to bring me under the provision of Assam Service Pension Rules 1969. And my lord, non-payment of the arrears salaries, my lord. Now, in this case, my lord, the government has already filed an affidavit. If your lordship now look into their affidavit in opposition, my lord, it is actually an admitted case. If your lordship look into their affidavit in opposition, my lord, page para 8, my lord will find that, my lord, this regular scale of pay was granted from 2012. But I have received it only from the 2015 only. So that area part I have to get, my lord. And so far, my lord, the cover is under the Assam Service. My lord, pay para 8, lordship will find of their affidavit in opposition, filed by my lord, Director of Elementary Education.
Yes.
Lordship, that with regard to the statement made in paragraph 12, 13 and 14 of rate petition, answer Dippan humbly state that the petitioner has passed certificate course in primary education from the IGNOU in the year 2008, and she was allowed to do regular scale of pay from 20 2010-2012 by Assam Director of Elementary Education, there was some order dated so and so, my lord. So they have admitted I am entitled from 2012, my lord. But as per my lord, paragraph 18 I have stated in my writ petition, I have received it from 2015 only, my lord. So in my writ petition, I claimed that para 18, if your lordship kindly look into, it space, my lord, 17, my lord. Page 17. That with their your humble petition are back to state that though the respondent took a policy decision to pay regular scale of pay with effect from 2010-2012, they also admitted as contained in the office memorandum so and the consequential orders written so and so, but she was paid fixed salary of 1,800 per month thereafter also till 28/12/2015 and only with from March 2015. So, my lord, with that regard, my lord, if your lordship look into their statement, it is contained in page 11, para 11. They have not denied it, my lord. They have said otherwise that I am not covered by the Assam Service Pension Rule, but so far this part is concerned, and my lord, that is not denied, that they have paid. If your lordship look into para 11, my lord. Para 11, lordship also. With regard to the statement made in paragraph 18, 19, 20, so and so of the writ petition, and deponent humbly back to state, retired, affirm the statement and the abandonment made in the previous paragraph, then said deponent further backs to since the petitioner granted regular scale of pay after 2001 to 2005, hence she has not been covered under the new contributor, they are covered under new contributory pension scheme. As such, PRAN number has been allotted to her under the new deferred contributory pension scheme. Accordingly, contribution toward the pension of the petitioner was deposited in the said PAN account of the petitioner. This is a different issue, my lord. Whether the petitioner come under NPS, new NPS, or my lord, under Assam Service Pension Rules. So far, area salary is concerned, my lord, they have not denied anything, said anything, my lord. But though they have admitted that I am entitled to 2012, my lord, and in my 18 of my writ petition, on categorically I have submitted, it is given with from the March 2015, my lord. And that is what my pair one of the pair in my writ petition, my lord. There is no answer to that. And secondly, my lord, so far whether I am coming under the Assam Service Pension Rule of 1969 NPS, my lord, this honorable court has already delivered a comprehensive judgment, my lord. And on the earlier occasion, my lord, this honorable court directed them to clarify this point, my lord. I have their judgment, my lord. This also came in the previous date, my lord. Whether this my case is covered or not, my lord, under the Assam Service Pension Rules, or my lord, I'll cover by the NPS, my lord. In my humble submission, my lord, they said they regularized my services in 1 to 2005, my lord. But regular scale was granted only from 2012. There is a difference distinction between regularization and regular scale. That was taken into consideration by this honorable court in Manoti Bashumatari's case, my lord. This Manoti Bashumatari's case has been reflected in para 30 of the judgment. That regularization is one thing, granting a regular pay is one thing. If your service is regularized prior to that NPS came into force, you are entitled to benefit of pension under Assam Service Pension Rules of 1969, my lord. Here in this case, I was appointed, I was regularized prior to 2005, my lord. That's if your lordship kindly say.
What is that regularization order?
My lord will kindly see this regularization order. Lordship will find 3/4/2000 page 30-32. Yes, my lord. Regularized with effect from so and so.
This regularization order was passed on.
On my lord, lordship will find from the original, if you look into 3/4/2001, my lord.
Okay, wow.
Yeah.
And,
Yes,
so
ma'am.
pass with effect from
With date of joining.
your date of joining in?
My lord, lordship will find and from the against the post. Then is hereby a regular date of joining. My date of joining is, my lord, 30/10. Sorry, my lord. My date of joining was, lordship will kindly see. Upon the, my lord, on 7/2/1996. Annex 3, my lord. Annex 3. This is the vernacular. Previous Annex 28 is the
Connected three.
table. This is vernacular.
Appointment order is that page number?
Appointment letter, my lord, will page number, lordship will find page 25. Because, my lord, why the stipend was granted, because, my lord, I have to go for the training, my lord, basic training. But, my lord, because of that, my lord, there is no availability of the, my lord, the facilities, all the teachers could not be deputed for the, my lord, basic training. And that is why the government brought this office memorandum of 2015, that all that, though it is not for the fault of these teachers, they could not complete their basic training. And therefore, this beneficial memorandum was brought in, my lord, that they should be given the regular scale from 1/20/12, my lord. If this memorandum, if a lordship look into this memorandum, my lord will find it at page is, my lord. This is my lord is page lordship will page 54, my lord. 54, my lord. The type copy is page 50.
Yes.
That memorandum clarified why regular scale was given. So there is a difference between regular granting and regular scale and regularization, my lord. That was been clarified by this honorable court in Banati Basumatari's case, and which has also been taken note of in, my lord, 2023 3GLT 451, my lord, page 30.
So you furnish a copy of the draft?
Lordship, I flagged also, my lord, para 30, where this Manati Basumatari's case have been taken note by this court. I flagged. Four. Hey, এখন খুলি গ'ল। থাকি গ'ল নেকি? লাষ্টৰ পেজটো কি আহিল নেকি?
You have two pairs.
Two pairs. My life, two pairs,
One is
basically.
for area salary.
Yes.
Other for bringing you under the pensionist. Okay. Yes, madam.
In this case, my lord, we have filed our affidavit, my lord, may produce para 4, my lord. Para 4, my lord, that with regard to the statement made in paragraph 4 of the writ petition, the answering deponent humbly begs to state that as reported by the Deputy Inspector of School, North Lakhimpur, letter number so and so dated 31/12/2021, the petitioner was appointed as stipend teacher at Uttar Khatani Lower Primary School by the then the Deputy Inspector of School, North Lakhimpur, order dated so and so 31/1996. Thereafter, the petitioner was allowed to draw the regular scale pay by the Assam order dated, my lord, 19/12/2015, my lord. It is in, my lord, page number, my lord, 59, my lord. Page number 59, my lord, petitioner name is shown at page 61, serial number 26, my lord.
after she had completed the course of certificate in primary education school in the year 2008, my lord. She has completed the basic training in the year 2008, my lord. And the petitioner was enrolled under the GISW with effect from 2011-2012 and registered under my lord NPS branch so number as reported by the DS North Lakhimpur, my lord. His fear is, my lord, his case may be considered under the, my lord, old pension scheme, my lord. But he has completed his basic training after 2005, my lord. After 2005, my lord, new pension scheme has already been introduced, my lord. It is, we have mentioned it, para 10, my lord.
It has been clarified in the judgment. My lord. Distinction be done between regular additional service and regular scale of pay.
Para 10, my lord, that with regard to the statement made in paragraph 17 of the writ petition, the answering respondent humbly begs to state that the government of Assam has introduced the NPS scheme for newly appointed state government employee with effect from 1st February 2005. The petitioner got the regular scale pay of with effect from 2010-2012. All employees under the state government who have been regularly appointed or given regular scale pay on or after 1st February 2005 has give undertaking in the new pension scheme.
That's right, but he was earlier appointed in the year 2019. When he was appointed?
1996, my lord. Yes.
Then he was given the regular scale of pay with effect from.
Regularized in a service, my lord. He was regularized in a service fee for 2021. But my lord, since the basic training was not completed, she was getting the stipendary, my lord. Because it was there to complete the basic training, then he will be confirmed with the regular scale of pay. Now, my lord, since, my lord, the government cannot depute all the teachers for basic training, my lord, so they introduced 2015 office memorandum. That those who have not completed, they will be getting the regular scale of pay from 2012, my lord, 2012 to 2012, 2000, 2010, 2012, my lord. Lordship, if your lordship kindly look into this office memorandum that I mentioned in page 50, my lord.
Page number 54.
Page number, my lord, 50, my lord. Page number 50, lordship. Page number 50.
Yes.
Yes, the elementary education provisional amendment has been came into effect from with effect from 2012 by notification number so and so dated so and so under section 3(4)(d) of the said rule.
That you were supposed to get the area salary.
Yes, my lord. Because that has been given by 2012, 2000. That has been clearly stated why this office memorandum was brought in. Then lordship, all the teachers appointed regularized after 2000 shall be before, my lord. Or other teachers who appointed regularized prior to 2012, either as per direction of the reference, otherwise shall be allowed to regular scale of pay from 2012, 2010, 2012. Page 52, my lord. Para 2. Page 52, para 2, my lord. That is the decision of the government. So, by pursuance of the decision of my entitled, they have granted, my lord, allowed me to draw the regular spell, but actually it is given from March 15. Therefore, this issue, my lord, the area cropped in, cropped up, my lord. And so far, my lord, this NPS and regularization of my lord services concerned, my lord, lordship, if I have just placed this judgment, if your lordship look into page para 30, page 13, my lord. My lord. So the matter, government will look into this issue, they may pay the area salary and this for regularity.
Regarding my
Because
area
my lord,
salary-
this regulation scheme, I think some matter is, my lord, pending before the government, they are taking some action on that, my lord. So far, this part is concerned, that may be, my lord, directed the government to consider both these things, my lord.
My lord, regarding area salary, my lord, our affidavit is silent, my lord. My lord may allow some time, my lord. I will take instruction, my lord.
My lord, this petition has entered 2020, she has already retired, my lord. This
My lord, he is
retired
getting under the
lady
new
is suffering,
NPS,
my
my
lord.
lord. New NPS, he
If
has
their
accepted.
affidavit is silent, my lord,
I will take instruction on only on my lord whether any regular area salary is pending or not, my lord. Regarding old pension rule and new pension scheme, it is clear, my lord, he is under new pension scheme, my lord.
No,
He has completed his basic training in the year 2008, my lord.
it's
And
not with regard to the basic. It is not depend upon the completion of basic training. Now I'll just only take my lord, my lord, this para 30 of the judgment, my lord. Lordship kindly see for the timing. Page 30 of the judgment that Manuti Basumotari's case has been quoted by this court and
December.
para 30 of the judgment, Lordship. I flagged it, my lord has got it. Correct. Para 30 of the judgment, paragraph 30. Lordship is got. My lord. Now, my lord, lordship will, and after quoting that lordship, just, yes, lordship elder, this aspect of the matter is also covered by the judgment of the coordinate bench in the case of Manuti Basumotari versus so reporting in so and so. Here, my lord will say paragraph 10, 11, 12, and 13 of the judgment was, my lord, quoted. Paragraph 13, regular appointment is service is one thing, and permitting an employee to draw a regular scale of pay after achieving certain qualifications is altogether a different thing. So on that basis, in that case, they are allowed to entitled to cargo. This is my lord.
Yes, regarding area salary.
well, I will take instruction, my lord, regarding area salary, my lord. Because our
And
affidavit
they
is
have
valid.
already filed a proposal, my lord, in 2018 itself for paying my regular, but till date, nothing has been paid. And she has already been deterred, my lord, like poor lady, my lord. They're getting nothing for 3 years, area is pending. And if they don't, if this, it is not paid, lordship may direct them to pay it immediately, if that it is not paid till date, lordship, they can.
Or if it is office memorandum clear.
Yes,
Right.
What instruction?
yes.
So whether my area salary was paid or not, my lord, that is not in our affidavit, my lord.
Well, they should have played, they have filed an affidavit when, my lord, lordship will kindly see the date on 22. If they would have been paid, it would have been reflected in the affidavit itself. There's a denied entitlement also.
When she has retired from service.
My lord, she has been retired from service on 2016, my lord. 31/10/2016, my lord. No? This 9 years, this is suffering, my lord. This is suffering.
And she approached before this honorable court on in the year 2021.
Whatever
My
it
lord.
is,
My lord may take it after a week, my lord. I will take instruction, my lord.
My only humble submission, let them obtain suffer. But if this area is not paid, my lord, them take initiative to pay it, my lord. If not paid, that is why I said, my lord. If it is not paid, it may be paid, my lord, in the meantime. If not paid, if paid, my lord.
My lord, my lord may
Then
take it
so-
after a week, my lord. I will take instruction, my lord. Whether
That
she
is
is
the thing.
entitled or not, my lord. That is also there. my lord. After a week, my lord, I need it.
Regarding entitlement, this office memorandum is clear.
Yes,
My lord.
and they have admitted also.
No, again lingering the matter for another.
Yes, my lord.
Who will direct him to verify? And
Yes,
if
yes.
she is entitled, you pay it.
Yes, yes,
She is
that will
not
be done, then can be done, my lord. That will solve both that will cover their interest also.
Well, only if the pair is only regarding to regular area salary, well, then my lordship may dispose it of. Directing the department to verify, my lord, whether she is entitled or not.
My entitlement is admitted, my lord.
Because my lord,
What
our
is the denial?
Regarding the NPS,
NPS, my lord, we have category stated, my lord. He has as per my lord, para 10, my lord. After first of,
some decision of this court are there.
my lord, I have not gone through that judgment, my lord. My lord may take it next or third, my lord. I will go through it, my lord. So, kuntu decision apni?
এই double heavy আছে। মনে করতে এটা ইমান দিচ্ছি। Double হয়ে গেলে যে-
This is not the only judgment.
হ্যাঁ, yeah.
One division bench judgment is also there
Yes,
on this point.
yes.
Anyway, you go through it. and,
বিজে কোড
correct.
লিখিলো লিখি ভুলাইলো বা
Correct.
2003, 3GLP.
451
Audit part, then the other on. Let's go. Then, and lateral functional area is already by the people. Then also to go to the list of a coordinate length of this for eight. That's it.
My lord, in the meantime, my only humble submission is this. So far, this NPS or pension is concerned, my lord. Let my learned friend go through this. But so far, arrear is concerned. Let the government examine it in the meantime. And if not paid, they should, because that is an admitted part. If not paid, my lord, let them examine government.
And other versus.
Yes, my lord.
DLP 451. Let her go through the decision.
Yes, my lord. But so far, my lord, arrear salary part is concerned. That is nothing to do with their decision, my lord. That is regarding the NPS and whether I am covered in the Assam Service Pension Law on NPS, my lord. But so far, arrear is concerned. So admitted the government may be directed to look into that aspect, my lord, in the meantime. If paid, fine. If not paid, they may take initiative to pay, my lord. Because of this, my lord, lady is 64 now. She is about 73.
Will finally dispose
The
of the matter
lordship.
on next day.
Night.
Letter
My-
letter of that.
These instructions have been awaited.
My lord, the joint committee meeting was supposed to held on 12/8/2025. But due to administrative reason, it was cancelled. So it will be scheduled. So sometime may be given to us so that I get the up-to-date instruction. At least 4 weeks, my lord.
4 weeks.
Notice to issue করো না?
Notice to program.
In the meantime, notice may be issued. Yeah.
Or may court be direct to consider my representation if schedule mention meeting.
The representation was yet to be.
Yes, yet to be disposed of. A series of representation has been filed, submitted before the concerned authorities, but no outcome has been yet to be furnished to us in petition.
My lord, already her matter has been considered and accordingly it is placed before the joint committee, my lord. So my lord, time may be given so that outcome of the joint committee can be get. Government has taken the process also.
But, sir, what are learned from? So hard. You thought learning. Starting from the first comment. Secondary.
Respondent number 1, 2, and my lord, 1 and 2, my lord.
What is the interim order? Take the first.
Your Lordship, this inquiry report, page 72, Annexure R.
Petition number article to the it's order. Dated 28/2013 issued by the Director. Memo number EC from SEC from 118 from 30 and also to the respondent purpose to provincial legal service of the as custom office teacher then Tengapara High School. And also to comply with the order of this court dated 24/6/2016 passed by WC. First the petition by the court and also first the interim order dated and the order passed by this court of the so dated 24/6. This will not issue the response returnable in forest, the bit taken by registered with ADM. However, no permanent say so Sarma entered evidence and it however extra requisite copy from some partnership. Sir Sarma learned for the respondent in secondary education part of state. The case of the was last before the joint committee.
Joint. 12/8/2025.
12/8.
2025.
The matter is being processed and utilized for drafting some time to obtain necessary inspection sticker. And accordingly, it is provided that since 4 months to obtain necessary inspection, then average is for the next day. This not COVID fixed it.
Lodge.
May I please, Your Lordship? Your Lordship, in this case, Your Lordship, the petitioner has put to challenge the disciplinary proceeding, Your Lordship. Basically on the ground that, Your Lordship, the criminal proceeding, Your Lordship, and criminal investigation is on the same set of charges is presently going on. Your Lordship will kindly come to the genesis of this entire criminal case against the petitioner has in a show cause notice issued by the petitioner against one of his subordinate employee, Your Lordship, who is the
What it says that the disciplinary proceeding is pending.
so cause, Your Lordship, has been issued. At that stage, I have replied, Your Lordship, and at that stage, I have come before this honorable court. Your Lordship may kindly come to page 21, Annexure A. This is from me, Your Lordship. Against so cause notice, I have issued against the one Dulu Pawe, who was a senior assistant in my office, Block Elementary Education Office, Your Lordship, Narayanpur. And on the ground that, Your Lordship, he has, Your Lordship, soon, Your Lordship, annual income return of the staffs, headmasters is to be submitted, teachers is to be submitted, Your Lordship. It is routed through him, Your Lordship. And while submitting that, Your Lordship, he has shown income less than what actually is, Your Lordship. That will, Your Lordship, ultimately would have resulted in, Your Lordship, loss to the exchequer, Your Lordship. And that's why I have issued this so cause notice, Your Lordship, at page 12, Your Lordship. You are hereby issued a so cause notice for misleading the undersigned by submitting false annual income statement. Lordship,
Page number?
Page 12, 21, sorry, Your Lordship. 21. Extremely sorry, Your Lordship. Page
Yeah.
20.
Yes.
From the petitioner, then Dulu Pawe, so cause notice. You are hereby issued a so cause notice for misleading the undersigned by submitting false annual income statement of 9 numbers of LP school teachers under the educational board regarding income tax for the financial year 2024-25. It indicates your negligence towards your duty as well as matter of fraud by misleading your higher authority. Therefore, you are directed to reply this so cause notice with notice valid reason on or before 10th March 2025. Why the matter will not be forwarded to the higher authority for disciplinary action, Your Lordship. Then, Your Lordship, he replied, admitting that he has committed a mistake, Your Lordship. That is at page 22, Your Lordship. His reply. Then what he did, Your Lordship, when these were pending, he lodged a complaint before the Your Lordship Vigilance and Anti-Corruption, Your Lordship, stating that I have demanded money from him, Your Lordship. In fact, through someone else, Your Lordship, not directly by me, Your Lordship. That is at page 23, Your Lordship, the FIR against me.
Who lost the FIR?
This Dulu Pawe, Your Lordship, against whom I have issued the show cause. Page 23, Your Lordship. May I read, Your Lordship?
Thereafter, what happened?
Your Lordship, I was arrested, Your Lordship, in this connection, granted bail, Your Lordship, suspended from my post, Your Lordship. And in the meanwhile, Your Lordship, this so cause notice was issued, Your Lordship, which is at page 40, Your Lordship.
Yes.
You are hereby asked to so cause under Rule 9 of the Assam Service Discipline Appeal Rules 1964, read with Article 311 of the Constitution of India. Why any of the penalties prescribed in Rule 7 of the aforesaid rule should not be inflicted on you on the charges mentioned below based on the statement alleging attached herewith. Whereas it has come to the notice of this office that you were serving as a block elementary education officer BEO Narayanpur. We were arrested on 12/3/2025 in a trap laid by a team of officers of Director of Vigilance and Anti-Corruption Assam in connection with the case number ACB PS case number 28/2025 under section 61(2)(a) BNS read with section 7 of Prevention of Corruption Act 1998. Whereas it has come to the notice of this office that the case of originates from a complaint filed by Dulu Pawe, Your Lordship will note, Senior Assistant at the Office of BEO Narayanpur District, Lakhimpur, Assam. It has been learned that Sri Dulu Pawe, son of Sri Punaram Pawe, who is a Senior Assistant in the Office of the BEO Narayanpur District, Lakhimpur, is responsible for examining the annual income and Form 16 of teachers for the preparation of salary area bills and calculated the areas for 3 months, but after later on verify with the Treasury Office, where he was informed that the calculation should be for 4 months. He revised the calculations of submitted bills on 5/6/2025. Subsequently, you reviewed the bills and identified discrepancies in 9 numbers of documents and issuing so cause notice to Dulu Pawe, but you were not satisfied with the reply submitted by Sri Pawe that it has been alleged that Sri Dulu Pawe contacted one Mohim Debojit Choikia to explain the matter to you. Accordingly, Mohim Debojit Choikia talked with you on 10/3/2025. Mohim Debojit Choikia informed Sri Dulu Pawe that Sri Dulu Pawe to give rupees 50,000 as a bribe to you. Thereafter, Sri Dulu Pawe met you and you had directed him to speak with Mohim Debojit Choikia. Sri Dulu Pawe is not willing to give bribe to you, and Mohim Debojit Choikia, he recorded the conversation held between him and you and Mohim Deka Choikia in his mobile phone handset. Thereafter, on 12/3/2025, Dulu Pawe lost the FIR Director of Vigilance and Anti-Corruption Assam Guwahati for taking legal action against you and Mohim Debojit Choikia and shared the audio recording having bribe demand conversion. Whereas on receipt of the complaint petition, a trap team was constituted by the Directorate of Vigilance and Anti-Corruption Assam. Mohim Debojit Choikia, head teacher, Rangpur Betoni LP School, son of so-and-so. Assam was apprehended immediately after they accepted part of the demanded bribe of so-and-so from the complainant in conspiracy which in a trap operation. The tainted bribe money was immediately recovered from inside the box and dashboard of Hyundai i20 vehicle bearing so-and-so Mohan Debojit Choikia, head teacher. Thereafter, we are also apprehended for demanding bribe and accepting in conspiracy and through the co-accused Mohim Devojit Soika, head teacher, after getting sufficient evidence, you Mohim Devojit Soika was arrested in connection with ACB PS case number so and so, so and so. Whereas UN Mohim Devojit Soika was produced before the Honorable Special Judge Assam Guwahati. Whereas your actions detail above has lowered the credibility of the government and the position held by you as representative of the government audit accounts to gross misconduct and breach of trust. Your actions also contravenes Rule 3 of Assam Civil Service Contract Rules 1965, which mandates that every government servant at all times maintain absolute integrity and devotion to duty and do nothing which is unbecoming of the government servant. Therefore, you are charged with gross misconduct, breach of truth, trust, and
Mr. Portago,
Lord.
what is your prayer in this?
my prayer is, your lordship, essentially, your lordship, to your lordship's status and was your lordship, the disciplinary proceeding on the ground that when the same set of facts, your lordship, a criminal investigation and criminal proceeding is continuing, at the same time, disciplinary proceeding cannot be continued, your lordship, as has been held by our High Court, your lordship, also Honorable Apex Court. Since your lordship has seen, your lordship, it has its origin in an FIR lodged against me by one Dulu Pawe. Ultimately, it will have to be proved, your lordship, in the criminal proceeding, whether I have done this or, and your lordship will note, the money has not been recovered from me, your lordship. It is recovered from someone else, your lordship. So therefore, your lordship, what role they have, your lordship, to that, your lordship, only after investigation, everything will become clear, your lordship. And at this stage, if even assuming, your lordship, I would have to participate in the disciplinary proceeding, it will amount to, your lordship, disclosing my defense, your lordship, which would ultimately affect me in my criminal proceeding, your lordship. That's the problem here in the disciplinary proceeding. Lordship, I will show, your lordship. This is one judgment, your lordship. This is of our High Court Division Bench, your lordship, 2022 SCC Online Guwahati.
The decision of the Supreme Court.
Lordship, that is also your there. Paul Anthony, your lordship, 1999 3 SCC 679. In our High Court judgment, your lordship, Division Bench, Paul Anthony has been relied on, your lordship. If your lordship takes up our judgment, your lordship, High Court's judgment, কোনটো আমার টু কমিক কাডু এটো হল 2012
The decision of the Supreme Court.
lordship
That
that,
11th paragraph.
lordship that your lordship will get it at page para 22, your lordship. Para 22. After your lordship discussing everything, your lordship, previous decisions of the honorable court, the conclusions which are deducible from various decisions of this court are referred to above are: departmental proceeding and proceeding in a criminal case can proceed simultaneously, as there is no bar in their being conducted simultaneously, though separately. Then I am relying on this. If the departmental proceeding and the criminal case are based on identical and similar set of facts, and the charge in the criminal case against the delinquent employees of grave nature, which involves complicated question of law and fact, it would be desirable to stay the departmental proceeding till the conclusion of the criminal case, your lordship. Now, here is a case, your lordship, where your lordship will see the manner in which everything has developed, your lordship. So there is a complicated question of fact is involved so far as, your lordship, my involvement is concerned, your lordship. And therefore, your lordship, in my humble submission, your lordship, this is a case, your lordship, where disciplinary proceeding authority ought to have waited for the outcome of the criminal case, your lordship, at least what they have found in the investigation, your lordship. Whether it takes the form of a charge sheet or, your lordship, final report, your lordship. And in the second judgment, your lordship will get that specifically, your lordship, of the our High Court, your lordship. Para 27 onwards, this honorable court discusses, your lordship. There is a reference to Paul Anthony, your lordship. Para 27, your lordship. Then, your lordship, specific paragraph, your lordship, will kindly come to para 30, your lordship. May I read, your lordship? However, So far as the second charge is concerned, this court has observed that the concerned criminal case is still at the trial stage. Under those circumstances, it has to be examined as to whether the correct approach was adopted to go ahead with the disciplinary proceeding. Since the charge is same in both in the second criminal case and charge number 2 in the so cause notice, it was not proper on the part of the disciplinary authority to go ahead with the second charge, as the same would amount to exposing the defense of the writ petitioner in the criminal case, Your Lordship. And that is why, Your Lordship, this was the what Your Lordship, Honorable Court says, Your Lordship held.
Yeah, what is the-
There are two set of prayer in the petition, my lord. One is challenge to the suspension and the other is to the initiation of the disciplinary proceeding, my lord. My lord, the suspension was on 12/3/2025, my lord. Within 3 months, my lord, it has been reviewed, extended for another 3 months. And in the meantime, the so cause has been issued, my lord. At this stage, my lord will issue a short notice, my lord, I'll reply.
No, regarding, there is also prayer for staying the departmental.
Department of I'll leave it to your lordship because apparently, my lord, the charges are same.
But it's it. Partner is for the partner. Ministry education.
My lord, element.
Yeah, the fix. Portland. Memo number EEF. That's 680-890. Program 9, 2025, issued by the Limited Secretary to the Governor of Assembly. Whereby the plans of the suspect. And also silence the disciplinary proceeding indicated by the so-called appointed. So-called appointed 7/6/2025. Memo number ECF 630-890. And all the way. To the who is most important. Supportable learning concept for the that by the biggest was serving as
Block Elementary Education Office.
In Ireland for learning. Alright. He was placed under suspense on the basis of allegation legal agency by Blue Power.
Power.
And also on the basis of an FIR lost by Blue Power. The ACP police station. Assam has registered a case. The ACP case number, the ACP case 2025.
Lordship.
161. Small a, ENS 067A of prevent the number of 98. After the respondent of purpose by so-called notice dated 7/6/2025 has initiated departmental proceeding agency upon the same set of facts. Same set of facts. And Mr. Portago submitted that in view of the decision of Honorable Supreme Court in the case of Paul Lenton and Paul Lenton versus Harrod Gold Mines Limited and another reported in 1999 PSCC 679. 679 especially with respect of clause number in respect of observation by paragraph 32. 32. The respondent authorities cannot proceed with the departmental proceeding. While the criminal case is pending against the present petitioner upon identical and similar set of facts. And till the disposal of the criminal case, the departmental proceeding would to have been stayed by the responsible. And under such circumstances, Sir Waterford submits that the departmental proceeding so hide local notice that they so maybe state. Maybe state. Start posting internet council setting up respondent to education department. Submits that. But this is notice may be issued. Then he will file a reply. I will and in perfect order. Right where there being guided is third. Posting submits that. The court has to take it up in view of the decision of the Supreme Court in the case of online certificates of fact. Having heard the submission of card and complete productivity. Now, counsel for both the parties, I have carefully gone to the petition. So, part of the Supreme Court in the case of online. Whereas they publish speed of the response. Return implementation. 2 weeks.
Well,
However, no formal notice is required to be issued. You are representing all the.
all my lord.
No formal notice is required to be issued. Respondents are being represented by Mr. Kusik. Guarded counsel for the. Standing counsel for the. However, extra repeats a copy of the release parties here to the rules of the. Taking note of the submission of the board. And also the submission of the posting and something of the respondent of the case and also taking note of the decision of another Supreme Court in the further proceeding. The disciplinary proceeding initiated against the petitioner stands state till return of the case of the corrects.
Deeply obliged.
Obliged.
So, 2 weeks.
Instruction received, Your Lordship. It is stated that he remained absent in the school without prior intimation to the principal of that school. The principal also stated that he sent show cause notice to the concerned teacher many times and tried to contact through mobile phones. But the teacher did not respond him, rather replied to the show cause notice. He started sending leave prayer to the principal through post office. I would like to place it before you.
You have received a representation filed by him.
Your Lordship, he was not responding to show cause notice and the leave prayer and the leave prayer itself, it's a.
Your instruction ought to have been in respect of the representation filed by him dated 17/10/2024.
Stand by post, my lord, and all the documents are sent by post.
Can you report? Short date may be given, Your Lordship. I will try to convey.
We will sort that. So we are disposing of the petition, first dispose of the representation filed by him. Yes.
Yes, sir.
Within a period of
If, if it is properly received by the concerned authority.
Stand by registered post. Like,
Deeply obliged.
Your lordship instruction was called for, your lordship.
Instruction received, your lordship. I would like to place it. মই খালি ফার্স্ট পেজটোহে দিব পাৰিম। He himself signed a transfer petition, your lordship, transfer. On his own request, your lordship, the transfer was done, your lordship.
Nowadays, that is the procedure, your lordship. We will have to.
Second paragraph onwards, your lordship, I would like to read it.
Yeah.
The headmaster of Jamuguri Adarsh High School has submitted a report dated 18/8/2025 to the undersigned regarding release of Sri Okhim Bora and stated that Sri Okhim Bora, which is the present petitioner, has been the secretary of the school bank since 2016 to till date, but he has not conducted any audit even after requesting him several times. The issue regarding transfer Sri Okhim Bora has been discussed with SMDC members that consist of retired teachers, present teachers, and staff of the school, and came to resolution that Sri Okhim Bora, which is the present petitioner, will be released from school only after he clears all his dues and audit of his school bank. The report of the headmaster along with his enclosure are enclosed here with your lordship. That has your lordship already annexed it, your lordship. He was not cleared his, your lordship, amount, your lordship. He has to first audit it, your lordship, and clear all his dues, which is pending. And he is also, your lordship, secretary of that school bank since 2016 to till date, your lordship. That consists of, your lordship, some present teachers and retired teachers.
Lordship may kindly come to para 11 of my writ petition, your lordship.
And your lordship, in my first paragraph itself, your lordship, third line, your lordship, that your lordship clearly denotes that on his own request, the posting was, the transfer posting was issued.
Para 11, your lordship. May I read your lordship, para 11?
Yeah.
That the petitioner begged to state that so far as not issuing his release letter order, the concerned headmaster of the aforesaid school in concern has been nothing but beating on the bush. The petitioner has been told that since he used to be the secretary of the self-help group among the teachers, audit is not complete as regard to the same of the petitioner. However, when the petitioner sat with the audit team, it is found that petitioner has no outstanding financial commitments, payments. Rather, he is entitled to few remuneration. Moreover, the self-help group is purely a private affair without having anything to do with the official duty. Therefore, that cannot be a ground to withhold his release from the school in question. The petitioner further begs to submit that he has also offered audit team with the salary account bank checks so that they can deduct any money if found to be in the deficit from the petitioner side. However, the same was refused to be taken by the headmaster of the concerned school even when the audit team was totally ready to accept those checks from the petitioner, your lordship. I am ready, your lordship. I am handing over my checks, your lordship, the salary account.
Let the headmaster maybe appeared, your lordship, in this matter, your lordship, since he is
And that
himself admitted the fact, your lordship, that he is the secretary of that school bank. And your lordship, once it hand over, your lordship, he can go, your lordship. Otherwise, the amount which has been dues, your lordship, it will not get back by those teachers, staffs, and other retired persons. It is for the amount to not disclose. Let the notice may go, your lordship. Let the headmaster be appeared, because in this matter, your lordship, it is necessary to appear. The headmaster appearance is necessary here.
Please go to this condition made in the paragraph number 11.
Oh, wow, headmaster.
They have not come up with, your lordship, how much amount I am to pay, your lordship. And this says, your lordship, there is no concept called school bank, your lordship. It's an
We are not appearing for headmaster, your lordship. That is the private respondent, your lordship.
Headmaster is function under them.
No, your lordship. We, till date, your lordship, we are not appearing on behalf of headmaster, your lordship. Inspector of school, we are appearing, but not headmaster. Under, it may be, but we are not represent him. Yeah.
You are the authority to take action upon him. You
They are
have
the
to
authority.
release the petition.
It is the director who has issued the transfer order, your lordship. And they have, if there is something, your lordship, they should have written to the director, your lordship, the headmaster, the IS. Everybody is there, your lordship, above the headmaster, your lordship.
IS is.
Release the petitioner within 15 days from the
Right.
they are disclosing this.
Keep your life.
কি করলো? কি করলো?
Right, please, Lord. 20 and 21. Here in this case, my lord, petitioner before your lordship was a, my lord, LP school teacher, and inadvertently he was overstayed in service. And accordingly, respondent authority contemplated to recover, my lord, salary from him. Then he approached before this honorable court, and this honorable court, my lord, passed judgment and order in his favor. It is at page 17, my lord. I have annexed, my lord. And discussing, my lord,
For me, whether you have filed the reply, the affidavit.
my lord, one reply I filed, my lord.
Where?
My lord, it is reply affidavit 22nd July, my lord. It is as per my record, my lord, it is from page 44 onwards.
It is ready for hearing.
My lord. Only thing is that lordship kindly available just, my lord, it is already clarified, my lord, in the judgment itself, my lord, after, my lord, the page 35, lordship kindly have a look. Article, my lord, page 34 under paragraph 20, it is given, my lord, direction. Then, my lord, after judgment, this honorable court observed, my lord, page 35, paragraph 21, my lord.
Yes.
And lastly, my lord, it was also page 36, my lord, last part, my lord.
from my lord 1, 2, 3, 4, 5, 6th line, my lord. Page 36, it was clarified that, my lord, this is not acceptable, my lord, and if it should not, state government should take, my lord, measures that should not be done, my lord, in future, and it is done, my lord, the officer who are responsible to keep the, my lord, incumbent in overstay service, my lord, that should be recovered from them. My lord. So therefore, there is nothing to become, my lord, confused about this order, my lord. And the operative part of the page 20, direction part is page 34 is very clear, my lord, paragraph 20, my lord. Page 34, paragraph 20. Consequent, this court therefore dispose of the both the writ petition with the following observation and direction. The communication dated so and so issued by the block elementary education officer is set aside and quashed, my lord, regarding recovery, my lord. The respondent so and so amount is also not to recover. The respondent authorities are directed to fix the retirement benefit of the petitioner on the basis of petitioner's actual date of superannuation, that is, which is the basis upon the date of birth recorded in the HSLC certificate. The respondent authority, including the elementary education department and a director of pension, are directed to immediately process the pension of the petitioner so that the petitioner receive his arrear pension as well as all other pensionary benefit at the earliest. The said exercise is completed within a period of 4 months from the date of certified copy of the instant judgment and order is served upon the respondent. And it is, my lord, based on, my lord, lordship, kindly have a look in this judgment, my lord. 3 judgment of the Honorable Supreme Court was referred, my lord, and the relevant portion is page 39. Page 39, my lord, it is a part of the, my lord, state of Bihar and others versus Pandey Jagdish Shwar Prasad reported in 2009 3 SCC page 117, my lord. And the relevant portion, my lord, page 29, paragraph 23, it was quoted. Paragraph 23, my lord, without going into the question whether the appellant was justified after completion of 2 years from the actual date of retirement to deduct 2 years salary and other emoluments paid to the respondent, we may say that since the respondent had worked during that period without raising any objection from the side of the appellant and the appellant had got work done by the respondent, we do not think that it was proper that at this stage to allow deduction from his retirement benefits the amount received by him as salary after his actual date of retirement. Then another judgment, my lord, is quoted, and another part, my lord, paragraph page 30, paragraph 26. Paragraph 26 is that, my lord, again in Hari Singh versus State of Bihar, this court held that since the government had never put the employee on notice to indicate that the date of birth as entered in the service book was incorrect, though it could have done so, and since no notice had been issued to the employee concerned for accepting a date of birth other than the one entered in the service book, the order of retirement could not be sustained. From the aforesaid decision, it is evident that it was the duty of the state to put the employee on notice about his date of retirement, and not having done so, the appellant was not entitled to recover the excess amount paid to the respondent. And last one, my lord, page 32, my lord. Here, my lord, Honorable Supreme Court, my lord, State of Punjab and others versus Rafiq Masi, my lord. Whitewash.
Lordship, same council, same district, same establishment. Many cases we had come through.
This was one of the case where also he had tried to avail that benefit. This was dealt by coordinate bench, Your Lordship. So this should not be encouraged, Your Lordship. Yes. Very well, everything was dealt by the Honorable Court. It's a matter of public exchequer, Your Lordship. Para 24.
Yeah.
That after considering the facts and circumstances as well as contention advanced by this court is of the opinion that the interest of justice will be served and equity would be balanced by passing the following orders. The court has also taken into that it is not in dispute that the aforesaid period the petitioner had actually rendered his service. That action of the respondent authority to recover the salaries paid to the petitioner for the period of overstay, namely from the pensioner, is interfered with and set aside. It is, however, made clear that for the said period, the petitioner would not be entitled to any pension or provisional pension, and his pension would be calculated only from the date of when he had handed over charge, that is 29/12/2021. Your Lordship. Because in that period he had availed a full salary, Your Lordship. And if we go into deeper, it is equally the duty of the, if you go to the pension provisions, equally the duty of the employee also to inform the authority that he will be retired by such and such, Your Lordship. And in this particular establishment and in this particular district, and even this particular matter also has been done by the same council, Your Lordship. So these, in series of matters, they had been taking this benefit, that we have not been informed. It is the duty of the authority, but it is equally responsibility of the concerned employee also. If Your Lordship permits, I can show the provision. It is reflected in the pension manual.
File your affidavit.
In the contempt petition, we have filed, Your Lordship, along with.
Where
Con-
you have taken assets in your affidavit.
In our affidavit, we have taken the stand that in the period where when he had availed the salary, we.
Actually, he is responsible for the same. You have submitted that.
I can make a mission lordship here, lordship.
No, I am asking whether he has taken successfully in his affidavit.
Perhaps in writ petition,
Lordship, here, I may something, lordship, whether the petitioner will be entitled to dual benefit. He asked for pension and salary for the same period, lordship. Lordship will look, and that is the prayer that my learned friend has made over here. He's asking for,
No, in this judgment, it was made clear.
yes, lordship, that is, the same prayer has been made in this writ petition. He's asked for a certain period where he has already been paid the salary. Now he's asking for pension also for that period, lordship. Whether that is acceptable, lordship, that is the main question over here.
No, that has been answered in this.
Lordship.
from our open eye, how can we let the public exchequer go in that way? That is the question that is in dispute, Your Lordship. That's why we are making our objection. It is not that he is a layman, he is a teacher who had served for near about decades. And after that, he had committed that mistake and now putting the blame upon the authority. And it is equally responsible for him also to inform the authority. Very well knowing that this is public exchequer, Your Lordship. Not that it will go from someone's own pocket.
Friend has made a statement that he has got the salary for a certain period. Now, for that same period, he's asking for pension also.
Only, my lord, with all respect, my lord, may I think, my lord, may I allowed to submit one thing? My lord? For pension, my lord, principle of all this judgment is that, my lord, so far I have understood, my
That's
lord.
right, the following year, in this judgment, WPC number 554 of 2020. It has been clear.
Yes, my lord, it is
What you were
in,
entitled to
yes, my lord.
and what you were not entitled to.
Yes, sir, it is clear in this, my learned friend.
Just one
judgment which produced-
further point, Your Lordship. Suppose he had rendered 3 years of excess service. Now, after he retired in 2000, he was to retire on 2019, and he actually retired on 2022, Your Lordship. Now, from 22, the authority has offered his the pension, your lordship. That 2019 to 22, that is the provisional pension. So provisional pension, it is given for him to sustain during the period where he doesn't avail the actual benefit, your lordship. So in this matter, already he has been availing the as salary, your lordship, for sustaining, your lordship. So that provisional pension, question of that provisional pension doesn't arise for that gap period.
Just that.
Yes.
Miserably, my learned friend is failed to understand basic concept, my lord. Lordship, suppose in re-engagement, my lord, after retirement, in many cases I have found, from army, my lord, retired and re-engagement police, their say pension is getting and
No, Mr. Porboya, you are the counsel in this petition.
Yes,
my lord.
yes.
If, my lord, therefore I have said, my lord, they have not filed, my lord, any appeal against this judgment, my lord.
So this judgment will cover it.
My lord,
Over your case.
no, my lord, because not, my lord, I am, my lord, on, my lord, past judgment already passed in my favor, my lord. Where, my lord, now, suppose your lordship is, my lord, not allowing my writ petition, meaning thereby, my lord, the earlier writ petition is, my lord, order is reviewed, my lord. Because, my lord, your lordship is otherwise not bound by this judgment also, because this judgment is passed, my lord, discussing on law, my lord. And, my lord, it is clearly provided, my lord. And lordship kindly will look why, my lord, it is not, my lord. And for pension, I have to, no service is required to be rendered, my lord. It is automatically from the actual date of my retirement, is pension is accruing, my lord, in the government exchequer, my lord. And, my lord, why I have paid salary, Supreme Court says that, my lord, this man has used in his service, therefore he is paid his salary, my lord. This is the main concept, my lord. Even in the re-engagement, my lord.
No, that's all right. For that period, you are not entitled to provisional pension. That
No,
is
lord.
the submission of
Some extent, they have also given me pension also, my lord. That period also, my lord. This overstay period also.
That's why I'm saying.
His understanding is, my lord, with all respect, my lord, miserably not correct, my lord. Because I worked as a, like a, my lord, re-engagement, my lord. My pension is automatically without service, my lord. It is being accrued in their exchequer, my lord. This is intact, my lord. And, my lord, I worked, I used, my lord, in the same post and paid, my lord, as a labor, my lord, cost, my lord. Nothing else, my lord. But he is, my lord, saying again.
Why my senior is not bothered about the public exchequer, I'm not understanding. It is just a matter of proper advice to your client. Somewhat it has gone wrongly, that one, because the similar matter you have, it is not that different counsel. Just a matter of proper advice to the client, your lordship. In that same establishment, wrong and wrong is going on.
What?
I'm for 4. Respondent number 4.
Only have for
Finance department. 2 and 8, lordship.
I am for 1, 3, 5 and 6. Madam.
judgment result.
Yes. Oblige, my lordship.
May it please your lordship. Lordship, before my learned senior starts, lordship, this matter is led by the learned advocate general, lordship. Lordship, today he has some personal difficulty, lordship. Lordship, may we please to fix it on some other hearing day, lordship.
Lord, this is a matter which was reserved for order in August 23. 2 years we could not get the judgment. Now it has been released, it has been listed. My learned friends should understand me, Lord. People are suffering. Advocate General is not there, somebody else should be there. Because he is busy with too many Lord activities. How can court wait for Advocate General? It's an important matters. People have to give up their lien, my lord.
Lordship, in that case, lordship, maybe please to fix it tomorrow, lordship. Tomorrow we don't have any difficulty, lordship, but not today, lordship. Lordship, I can understand the urgency, lordship. Lordship, the matter was reserved for on January 2024 for orders, lordship.
Tomorrow that with the
Okay, my lord.
agreed by
How can it be done this way, my lord?
Pardon?
I can do my part today if they do
Yes,
their
sir.
part.
Yes, lordship, we don't have any difficulty, lordship. And we'll note down and we'll give a reply on some other day, lordship.
not tomorrow.
Lordship, today also, my lordship.
What I was suggesting, my lord, subject to what your lordship may say, I would like to do my part. They can give the reply tomorrow
or anyway, my lord, up to your lordship. Yes. My lord, there is a written argument, if your lordship would kindly take that. A brief note, bully as a we are for the petitioner, my lord. If your lordship would kindly come to page 7 of that note, my lord, where I have given the list of dates. Actually, my lord, the petitioner before lordships, she was the head of Department of Chemistry of Dibrugarh University, my lord. When this post was advertised, she applied. 37/2020,
The list of date is not in this.
page 7, my lord, towards the end of that brief note, bully at us.
Okay, okay.
Yes. Page 7 of that note, my lord.
Yeah.
37/2020, 29th meeting of Academic Council of Krishnakanta Handikoi, State Open University resolved to launch a new program from HKBSTT. This is not a particular department in that university. So 14/8/2020 advertisement was published inviting applications for 4 posts of professor, including that of that particular branch. Then, my lord, in August 2020, a corrigendum was issued to the advertisement. 22/12/20, interview for the post was held. 23/12/20, 68th meeting of the Board of Management recommended the petitioner for appointment as professor in so and so. Then 24/12/2020, appointment letter was issued to the writ petitioner, Professor Jyotirekha Handik. Then the 1/1/21 petitioner joined as professor. 31/7/21, university submitted a proposal to UGC for recognition of BSc General under that particular stream. 12/10/21, UGC did not recommend the proposed BSc General program with remarks that SLM not ready. SLM means, my lord, to heavy SLM. Special learning materials not ready. Then, my lord, on 3/12/21, impugn letter was issued by Special Commissioner to the Government of Education Department. This was, my lord, by which, my lord, a direction was issued to, my lord, interfere with the appointment. So we approached this honorable court. Then this honorable court gave us an interim protection, which was subsequently on 15/3/22, the interim protection was vacated. Then following vacation of the interim order, my lord, the impugn order of termination was issued on 16/3/22. So, my lord, by way of an additional affidavit, this came to be challenged. Now, if your lordship would kindly come to the writ petition, my lord. Page 41. First, page 39, my lord, the appointment order.
Yes.
I'm glad to inform you that you were selected for appointment to the post of professor in Hiranyo Chandra Bhuya School of Science and Technology. HCBSS, this stands for Hiranyo Chandra Bhuya School of Science and Technology, under general terms and conditions to be regulated by Krishnakanta Handikoi State Open University Act 2005, as amended up to that. The statute, ordinances, and rules of university in force from time to time under the following terms and conditions. Name of the post, professor in Hiranyo Chandra Bhuya School of Science and Technology. Nature of the post, permanent. Then, my lord, the pay scale is there. Then probation. Subject to the provisions in the statute,
This appointment is made on provision for a period of 1 year from the date of joining. However, the appointing authority shall have the power to extend the period of provision. This offer of appointment may be withdrawn at any time during provision period based on administrative reason, which will be binding on you. So basically, my lord, the petitioner was appointed on provision. Then, my lord, also will kindly come to page 41. This was the communication which we challenged, my lord, in the writ petition. No, এখন কোনে দিলে? No, sorry, my lord. Please come to page 41, my lord. This was a communication by the Secretary Government of Assam to the my lord. Sorry, by the registrar to the Government of Assam. If your lordship would kindly come to page 43. I'm reading the subpara. It may be noted here that as the chairman of the selection committee, the then Vice Chancellor conducted the entire selection process relating to selection of the post of professor in Hiranyo Chandra Bhuya School of Science and Technology. In view of above, it may be stated that concern expressed by the Honorable Chancellor needs to be addressed by the competent authority. It may be so mentioned here that in an audience with the Honorable Chancellor, similar concerns were raised in presence of the present Vice Chancellor in charge, so and it was assured that future recruitment process would be conducted in a transparent manner as per the procedure. Now, it so happened, my lord, the then incumbent Vice Chancellor, during whose tenure the petitioner was appointed, my lord, may have fallen from grace, as it happens, my lord. So, therefore, my lord, some displeasure was expressed by the Vice Chancellor, and therefore, my lord, this communication was made to the government. Now, based on this letter, my lord, at page 44, third of December 21, now the government of Assam writes to the Vice Chancellor. My lord, we all understand these universities are, my lord, autonomous bodies. How government can interfere in these matters, my lord, I don't know. With reference to the subject cited above, I am directed to request you kindly to take necessary action as per statute of the Krishnakanta Hondigoy State Open University regarding anomalies in recruitment in respect of Dr. Jyotirekha G. Handik as Professor of Hiranyo Chandra Bhuya School of Science and Technology. So, my lord, government is writing to the Vice Chancellor that some action should be taken against the petitioner as they comprehend that there were some anomalies in the recruitment process. My lord, we challenge this order in a writ petition WPC number 6604 of 21 at page 45, my lord. At page 47, after issuing notice, as regards the prayer for interim, the court is inclined to provide that while there is no bar for respondent authorities to take action against the petitioner as per statute, but no final order shall be passed until further order from this court. So, my lord, by virtue of this, I continued. Then eventually, my lord, an application for vacating that order was filed, and the order was vacated on 8/12/21. Then, my lord, at page 48, this is the order, my lord, which is now being challenged in this present proceeding. The Board of Management was apprised about the letter received from Special Commissioner to the Government of Assam, Higher Education Department, white dated so-and-so, regarding recruitment to the post of professor in Hiranyo Chandra Bhuya School of Science and Technology. The same had a reference to an earlier communication to the Secretary to the Government of Assam Higher Education Department in response to their letter dated 8/10/2001 that enclosed a copy of the letter dated so-and-so from the Honorable Governor of Assam and Chancellor of the University requesting immediate necessary action for termination of appointment of Jyotirekha Hendik as professor. The matter was placed before the Board of Management for information and approval for compliance. After threadbare discussion, Board on principle agreed to comply with the directive from the Government of Assam and Honorable Chancellor. Resolution. Resolved that directive of the Honorable Chancellor as per communication received from Government of Assam letter be complied with. Board has further resolved that legal clarity be ensured by University on the language and content of the letter to be issued to the Professor Jyotirekha Ji Hendik, so and so, so and so. So, my lord, this is the resolution by which a decision in effect was taken to terminate the service of the petition. Now, my lord will kindly come to that impugn order is at page number 111. At 112, my lord. It was sent by mail, my lord. At page 111 is the first part. Then the operative portion is at 112. Page 112. In pursuance to the decision of the 64th meeting of the Board of Management held on 8th of December 2021, read with the provisions in the clause so-and-so under chapter 6 of the first statute of the university and terms and conditions of the appointment, the service of Jyotirekha Ji Hendik on probation as professor in Hiranyo Chandra Bhuya School of Science and Technology is withdrawn with immediate effect because of administrative reason and rejection of UGC to provide recognition to BSc General Program white letter dated so-and-so in Hiranyo Chandra Bhuya School of Science and Technology. My lord, apparently there was some communication behind the back of the petitioner. Government is writing letter to the registrar. Then Chancellor of the university also expressed some displeasure. All this taken together, my lord, resulted in that resolution of 64th meeting. And pursuant to the resolution, this impugn order dated 16th of March 22 was issued, citing two reasons. One, administrative reason, and secondly, my lord, UGC did not give permission to open BSc program. Am I clear, my lord? These are the two reasons cited in the order. Number one, administrative reasons. Who do not know what is this administrative reason? I understand, my lord, in Army, under the Army Act, CRPF Act, there is a provision, Section 11 of the Army Act, where under administrative reasons certain actions can be taken. But, my lord, as far as Article 311 is concerned, I am yet to come across, my lord, anything called administrative reason. End of the day, my lord, if I do not know the reason why I have been dismissed, then how do I agitate my grievance, my lord? Why it is said, my lord, a show cause notice should be very clear. Because the noticee, he must know what are the allegations against him. Otherwise, how does he reply? So these are all finer aspects of administrative law. So, my lord, two reasons are cited. One is administrative reason. Other is, my lord, non-recognition of BSc program by UGC. Now, let me deal with the first point, my lord. End of the day, Lordship is concerned with the decision-making process. There is a manner prescribed how a provisional service can be terminated. That manner has to be followed. If it is not followed, consequences will follow. Therefore, on the first point, my lord, let me place the regulation, my lord, conduct rules. A copy was given, I think it is there. Krishnakanta Hondigoy State Open University employees academic and non-academic service condition, conduct rules 2019. There is a conduct rule of 2019. এখানে লিখা। Conduct rule, Milord, yes. Milord will kindly come to page number 9. This is regulation 2 Roman 28.
Totally all the pages are not here,
Milord, page 9.
not there.
No, Milord, 28, Roman 28, 228. ইয়াত নাই, এইখন বেলেগ। এইখিনিতো মই কৈছিলো তোমাক আছে নাই। ঘূৰাই দিম দিয়া, দিয়াচোন ফটো দিয়া ঘূৰাই লম। Milord, my friend will hand over a copy. I'll give her one more. Milord. Milord will kindly come to page 9.
Parts are here.
Oh. Anyway, well, I'll hand over a complete copy.
Okay.
Please come to page 9, my lord. Roman 28.
Yes.
Service means employment in the university, whether permanent, temporary, or contractual basis.
Yes.
Then, my lord will kindly come to 14 at page 13. At page 13, an employee shall be a temporary employee of the university until his service is confirmed in the present post. Or an employee whose service is confirmed in any permanent post under university shall be permanent employee of the university. 15. Service of a temporary employee may be terminated by appointing authority without assigning any reason thereof, provided that such service of an employee on probation may be terminated with a prior notice of 1 month or 1 month pay in lieu thereof. So there is no dispute, my lord, that I am a temporary employee because I am on probation. I was yet to be confirmed. Therefore, clause 15 will apply with full force. What it says? The service of a temporary employee may be terminated by the appointing authority without assigning any reason thereof, provided that the service of an employee on provision may be terminated with prior notice of 1 month or 1 month pay in lieu thereof. So, my lord, what the mode prescribed is, if one is on probation, if he is to complete his period of service, in that case, either 1 month notice or 1 month salary in lieu thereof. Now, my lord will kindly take my written argument. Please come to page 2. Please come to page 2.
Yes.
The impugn order dated 16/3/22 is legally not sustainable, as the same has been passed in gross violation of the conduct rules of 2019. Rule 228 defines service. Service means employment in university, whether permanent, temporary, or contractual basis. Rule 514(1) provides that an employee shall be a temporary employee of the university until his service is confirmed in the present post. Rule 515 provides that service of a temporary employee may be terminated by appointing authority without assigning any reason thereof, provided that service of an employee on probation may be terminated with prior notice of 1 month or 1 month pay in lieu thereof. The admitted position is that following her appointment by order dated 24/12/20, the petitioner joined the university on 1/1/21. It is also an admitted position that interim order dated 8/12/21 passed in WPC was holding the field until 1/1/22, when the interim order dated 18/12/21 was vacated. Under the circumstances, petitioner completed 1 year of probation on 31/12/21. Be it as it may, on 16/3/22, when the impugn order was passed, the petitioner was a probationer, inasmuch as the petitioner was in service of the university, and as such, in terms of Rule 515 of the Rules of 19, the petitioner was entitled to a notice of 1 month or 1 month pay in lieu thereof. Same having not been done, the impugn order vitiates and not legally sustainable. But I don't think any other ground is required. This is good enough. I'll place 2 judgments on this, Miller. There is no dispute that I was on probation. There is no dispute that, Milord, my service has been dispensed with. Since I was a probationer, I was entitled to a 1 month's notice or a salary in lieu of 1 month, which has not been given. Yes. এখন দিয়ক না। মই দি দিম। আছে নেকি? এইটো আছে? হ'ব হ'ব। Yes. Now, if your lordship would kindly come to rule at page number 3, Milord. Rule 7.08 of chapter 8. Citation to Kumar. 2006 1 GLT 717. 2006 1 GLT 717. Rule 7.08 of chapter 7.
Yes.
Terms and conditions of Sainik School Society rules and regulations which govern terms and conditions of the appellant petition as follows. During the period of probation, the principal may terminate the services of any member of the staff appointed by him under his own powers after giving 1 month's notice in writing and without assigning any reason. Reciprocally, any member of the staff on probation may leave after giving 1 month's notice of resignation or surrender of 1 month's salary. So this was the provision, Milord, more or less similar. Now, Milord will kindly come to paragraph 11. Please come to para 10, Milord, at page 8.
Yes.
It is also equally well settled that law regulation is made not to be broken but to be obeyed according to the decisions of the apex court in catena of cases, one of which decision of the apex court is a constitution bench in Carter Singh versus so and so. Law is made not to be broken but to be obeyed, and the respect of our law is not retained by demonstration of strength but by better appreciation of reasons, better understanding of its reality, and implicit obedience. It goes without saying that achievement of law in the past are considerable, its protection in the present is imperative, and its potential for future is immense. It is very unfortunate that on account of lack of respect, lack of understanding, lack of effectiveness, lack of vision, and lack of proper application, in the present day affairs, law sometimes falls in crisis. Such being the well-settled principle of law, the respondents are bound to follow the said Rule 7.08 while issuing the impugn termination order, inasmuch as the said rule is framed to be followed and not to be broken. We may also refer to the decision of the apex court in so and so, wherein when a procedure is prescribed by the legislature, it is not for the court to substitute a different one according to its notion of justice. When the legislature has spoken, judge cannot afford to be wiser. But in the impugn judgment and order dated 30/11/2024 or 2004 of the learned single judge held that even if the procedure for immediate termination of service of a probationer during the period of probation without 1 month's notice is not prescribed by the said rule, the procedure adopted by the principal training school, Manipur, for issuing the impugned termination order for terminating the service of the appellant forthwith without giving statutory notice of 1 month is correct. So the Lanet Singhal just took the view that non-issuance of notice is not fatal. No doubt, the termination of service of a probationer is a very drastic measure taken by the concerned authority employer against the probationer. According to the well-settled principle of law, when a drastic power is to be exercised, it should be saved and except according to the prescribed procedure. The Constitution bench of the Apex Court in Hukum Chand versus so-and-so held that it is well settled that where a power is required to be exercised by certain authority in a certain way, it should be exercised in that manner or not at all, and all other modes of performance are necessarily forbidden. It is all the more necessary to observe this rule where power is so drastic of a drastic nature and it exercises in a mode other than the one provided will be violative of the fundamental right of natural justice. So and so. So para 18 is quoted, Miller. It is well settled that where a power is required to be exercised by certain authority in a certain way, it should be exercised in that manner or not at all, and all other modes of performance are necessarily forbidden. It is all the more necessary to observe this rule where power is of a drastic nature and its exercise in a mode other than the one provided will be violative of the fundamental principles of nature and justice. Now, in the present case, if the telephone, etc., in the facts of this case. So, therefore, my lord, eventually, your lordship will kindly come to para 14, my lord. The writ appeal which we are now dealing in is an appeal on principle, thereby that this court is exercising coordinate jurisdiction and it is very limited. With such limited jurisdiction and power, we have examined the impugned judgment of the learned single judge as to whether or not there is a patent error on the face of the record, as also to whether or not it is against the established principle of law discussed above in the factual context of this case. Regarding jurisdiction of the writ appeal of this court, reference may be made to the judgment of so-and-so, so-and-so. As discussed above, we are of the firm opinion that impugned termination order dated for terminating the service of the appellant writ petitioner without giving 1 month's notice in writing is in infraction of the said rule 7.8, under which 1 month's notice in writing is a mandatory for terminating the service of the probationer. Accordingly, there is a patent error in the impugned judgment and order. So, my lord, exercise of a power in a manner prescribed would be a nullity. Either you do it in this manner or you don't do it at all. I think, my lord, the other ground I can, press it to service. But if your lordship is satisfied, I need not go to the other point. Or let my learned friend argue on this point. Otherwise, if your lordship feels I can press my lord, what had happened? Normally, what happens, my lord? Anyway, my lord, regarding the other point, I'll just show it, my lord. Regarding that non-recognition by the UGC, that I'll just show. Now, if your lordship would kindly come to page number 62, my lord, how it operates. Yes. This year, my lord, UGC may not, next year, UGC may. So that has got nothing to do with my retention. Page 62.
Annexure L.
Yes, my lord. Annexure L. This is the proceedings of 58th meeting of the Board of Management of the University. Now, I'll have your lordship's kind attention to page 64. Launching of new program from the School of Studies. Kindly see, my lord. Undergraduate program. I was recruited because these programs were sought to be introduced. Then, my lord, will kindly come to page number 67. Now, my lord, university wrote to the authority at page 68, towards the bottom, starting of undergraduate, postgraduate course in science discipline on priority basis. Has your lordship got it, Miller? Yes. Then at page number 70, Miller, School of Studies, Hiranyo, towards the bottom, Miller, Hiranyo Kumar Bhuya School of Science and Technology. So these are the, Miller, different wings of the university. Then yes. My lord will kindly come to page number 93. Now this application was made by the university to the, my lord, UGC. Now kindly see at page 93, program applied for ODL undergraduate 1. As your lordship got it, my lord. There is a program applied for ODL open distance undergraduate 1. Then, my lord, will kindly come to page number 97. Now, this is Bachelor of Science combination of 3 subjects, Master of Arts Nepali, Master of Journalism. So this stands, my lord, approved. Then, my lord, will kindly come to page number 98. This is expert committee interface meeting in connection with the university. Yes. Please come to page 102. Now, pursuant to the application of the university, what UGC does, my lord, for example, Master of Arts Education recommended, Master of Science Information Technology recommended. Now, kindly see Master of Arts Journalism and Mass Communication not recommended, inadequate faculty. I'm just giving an example to show, my lord, how it operates. I'll just come to the portion where how it matters in this case. So as far as Master of Arts Journalism and Mass Communication is concerned, on 1/2/21, UGC did not recommend it. The reason being, there is no adequate faculty. Now, my lord, will kindly come to page number 10. Yes. Please come to page 107.
Yes.
Now, for the subsequent year, my lord, kindly see Bachelor of Science combination of 3 subjects not recommended. Why? SLM is, my lord, self-learning material, not ready. Then Master of Arts Nepali not recommended, inadequate faculty, SLM not ready. Kindly see Master of Journalism at page 102. It was not recommended. Now it is recommended. So it is a continuous process. Now, my lord, what is the significance of this inadequate faculty SLM? That we will get to know from the UGC regulation. So I have demonstrated, my lord, that this is a continuous process. If in a particular year, a particular program is not recommended, it is not an, my lord, end of the road. Subsequent year it is given. Now, one of the reasons cited is that there is no, the BSc program has not been approved, therefore I am not required. That is his impressions ought to be given. Now, Milord will kindly take this regulation of ONGC, UGC, Milord. It's given, it is that yellow lady. Milord, this is a regulation of,
4th of September 2020.
one second, Milord. Yes, no, 23rd of June 2017, Milord. First page is of Hindi, Visit Gazette of India.
Yes.
Please come to page number 42, Milord.
Yes.
Part 3, maintenance of infrastructural, academic and other quality standards by our higher educational institutions. Has your lordship got it, Milord? Yes. Now please come to 7, self-regulation through disclosure, declaration and reports. Now please come to Roman 8 on next page at page 43. Let me read it from the beginning, Milord. A higher educational institution offering programs in open and distance learning mode shall display on its website a declaration by authorized signatory not below the rank of registrar authenticated that the following documents have been uploaded on the institute website, namely, please come to Roman 7, Milord. Information regarding any new program launched and those proposed for the next 2 years. Has your lordship got it, Milord? Then 10. Complete information about self-learning material, including name of the faculty who prepared it, when it was prepared, the last updated source of self-learning material, reference to self-learning material, etc. Now, my lord, if I do not appoint a faculty who will prepare this self-learning material, so there is no bar under the UGC regulation. Therefore, the alibi that BSc program was not approved by the UGC, therefore we are dispensing with your appointment, is a, my lord, farce. This is not what the bare eye meets. Kindly see, my lord. Complete information about self-learning material, including the name of the faculty who prepared it. So, name of the faculty is, my lord, Jyoti Rekha Handik. She will prepare it. So, my lord, 2 reasons has been cited. One is administrative reason. We do not know what is the meaning of administrative reason. And secondly, non-recognition by UGC. So, my lord, that means an action has been taken based on some complaint. What is this administrative reason? All that you are doubting is the incumbent VC who was there when I was appointed, he did something wrong. Therefore, you removed him. Therefore, you appointed somebody else. I was a respected professor and head of the Department of Chemistry of Dibrugarh University. Lord, I am a faculty who goes to on all India thing, Lord. I am a guest speaker in so many universities. Lord, I have been defamed by this action. How to restore my lost pride? Now, therefore, my lord, what I am saying is, this is an alibi. Now, please come to the, my lord, my written argument. Lord, on the proposition that at page 3, that when a manner is prescribed, regarding the first point, I am relying on the judgment, my lord. These are all well-known judgments. If a manner is prescribed, it has one. Now, please come to Roman 2. It is respectfully submitted that the expression matters relating to employment used in Article 16(1) is not confined to the recruitment stage, but comprehends all matters in relation to the employment both prior and after. It is further well settled that Article 14, 15(1) and 16(1) form part of the same, it's not with, of the same constitutional code of equality and supplement each other. In the instant case, by not adhering to the prescription of Rule 515 of the Rules of 19, the state petitioner has been denied equal protection clause adumbrated in Article 14, 16(1), and as such, the impugn order vitiates. My lord, in this Beliappa's case, what Supreme Court said was, my lord, I'll just place that judgment. I think it's that copy. Ekon Sabna, 1979 1 SCC 477. A bunch. 1979 1 SCC 477. Yes. My lord will kindly come to para 19. My lord, it's not that when it comes to appointment only, Article 14, 15 and 16 applies. Article 14, 15 and 16 applies in all its facets. Kindly see, my lord, para 19 at page 483. It is now, well, it was also a case of a temporary government servant, my lord, Beliappa. It is now well settled that expression matters relating to employment used in Article 16(1) is not confined to initial matters prior to the act of employment, but comprehends all matters in relation to employment, both prior and subsequent to the employment, which are incidental to employment and form a part of the terms and conditions of such employment, such as provision as to salary, increment, leave, gratuity, pension, age of relaxation, promotion, and even termination of employment. It is further well established that Article 14, 15(1) and 16(1) form part of the same constitutional code of guarantee and supplement each other, if any authority is needed, etc. So it's not that, my lord, Article 14 and 16 will have application only in the case of appointment. In different facets of connected with service matter, my lord, this has an application. Now, the moment you have denied me the guarantee provided under Rule 515, that means I have denied equal protection of law. Therefore, it is violative of Article 4. Then, my lord, my third point I have brought out, my lord. Now, this is regarding, my lord, though, my lord, in the impugned order, nothing has been spelt out, but going by the affidavit of the university, my lord, it appears that some allegations are there. Regarding fairness of my maybe selection.
Yes.
If allegations are there, that means the decision has been taken based on some allegation. That means it is the foundation, it is not motive. Therefore, my lord, Article 311 is attracted. As a provisioner, my lord, if, my lord, as a provisioner, if I am discharged based on some allegation, then I am entitled to the protection under Article 312. They should have given me a notice that you have secured appointment by this and this. So called why your appointment should not be discharged. That was not done. So as a provisioner, my lord, I have that right. And it is not a simple order of discharge. It is a stigmatic order. That's why I have brought out in this third point, my lord. My written argument, para 4, page 4, my lord. What is evident from the factual, page 4, my lord. What is evident from the factual aspects narrated herein above, and also taking note of the stand taken by the university in their affidavit of opposition, as well as communications which are placed on record, what the respondent university would like to contend is that petitioner's entry into the university is tainted. The other ground indicated in the impugned order is the rejection of UGC to provide recognition to BSc program. Dealing with the first part, though it has been described as an administrative reason in the impugned order, petitioner would like to contend that first reason is founded on misconduct. Second ground taken in the impugned termination notice relates to rejection of UGC to provide the recognition to UGC general BSc program. Said ground is utterly perverse and legally unsustainable. The reason for rejection by UGC, which can be seen from page number 109 of the writ petition, is that SLM not ready, inadequate faculty, and SLM not ready are reasons which are generally assigned by UGC. For example, from page 102 of the writ petition, it can be noticed that Master of Arts Journalism and Mass Communication was not recommended by UGC on account of inadequate faculty. However, from page 109 of the writ petition, it can be seen that program Master of Journalism was approved, recommended by UGC. To appreciate the controversy, it would be beneficial to refer to UGC so-and-so regulation, which I have already placed, Milord. Then Milord will kindly come to next page. A bare perusal of clause 7, 8 and 10 would reveal that appointment of faculty is prerequisite amongst others for preparation of self-learning material. Therefore, reason assigned in the opinion order that UGC did not approve BSc program is utterly misconceived, inasmuch as the said reason is not at all germane. The refusal to approve BSc program was not on account of SLM being not ready. Under this circumstance, unless faculty is recruited and appointed, there can be no means to prepare SLM. The refusal by UGC to grant approval has to be understood in proper perspective. The process of seeking permission from UGC to start different program is a routine exercise, and refusal on one occasion on account of one reason a refusal of one account of reason or other does not mean it's refusal for a time to come. These are infirmities in the decision-making process. Normally, misconduct is attributable at a stage when petitioner discharges duty assigned. Issue is whether allegation associated with recruitment can constitute misconduct. It is the petitioner's specific case that allegation which form the basis for invoking administrative reason in the impugn order is anomaly in recruitment of the petitioner. In other words, some allegation form the basis. In respectful submission of the petitioner, whenever discharge of a petitioner is founded on allegation, such an order would be violative of Article 311, principle of natural justice, if delinquent is not put to notice. In this regard, the petitioner seeks to refer and rely upon the following. My lord, these are all well settled principles, my lord. Now, when you rely upon some allegation, then you must conduct an inquiry, at least in consonance with the principles of natural justice. That you have not done. First, you have violated the very prescription then, my lord, the second point is if a manner is prescribed, it has to be done in that manner or not at all. It will be shaped. Third point is, my lord, regarding this refusal by or non-recognition by UGC, that is a routine exercise. It is neither here nor there. End of the day, my lord, if faculty is not appointed, how the self-learning material will be prepared, who will prepare it? So, my lord, they were trying to justify their action. Now, the question is whether it inspires your lordship's confidence. End of the day, my lord, your lordship will have to be satisfied. My lord, I am a respectful person of the society. I was doing a very good job in Dibrugarh University. I got an opportunity. Actually, my lord, the petitioner's sister is having some serious heart treatment. She is unmarried. She stays with the petitioner. Therefore, for her better treatment there in Guwahati. That's why she came over. That's why she applied, she got the post, she joined, then all this happened. Now, merely because, my lord, some people felt or comprehended that there is something, because they perhaps, my lord, they had something, some axe to grind with the vice chancellor, who was at the relevant point of time, was the vice chancellor. Now, what am I to do with all this thing, my lord? Have I not been defamed when it says that for administrative reasons, my appointment has been withdrawn or recalled?
Now, where are you?
Now, presently, my lord, what had happened? I came on lien initially for 1 year. Then, under the relevant rules, I am entitled to 3 years lien. which also expired. Then I was extraordinary 3 months I was given. Thereafter, there is no way. I put in my papers for voluntary retirement. But then, my lord, we are concerned with a stage when I was very much in service because I have not been paid anything. Now, my lord, while the lawyer was arguing for the university, the our justification was when there is no car, why do we need a driver? But going by the UGC norms, you need not only the car, you also need a driver. The argument was there is no requirement of a car, so why do we need a driver? Because there is no BSc program. Therefore, why should there be a driver to run the car? But that's not correct. Correct position is, as per UGC norms, you need both. You need a car as well as a driver. So this is the case. I'm not troubling your lordships with by reading the authorities. I have given all the authorities. It's a well-known proposition, my lord. Since you comprehend that there is something amiss, then you want to inquire it. That means you are relying on some allegation. Then I must know the allegation if you want to condemn me. Without giving me the reasons, how can you condemn me? That is the case. So therefore, it's a fit case, my lord, where lordships will allow the writ petition and my lord restore the pride of the petitioner, my lord. It's not, my lord, it is not done actually. And but subject to what my other side say, my lord, I reserve my right of reply. And deeply obliged, my lord. Devashish Bora, sir.
Harbour, your lordship. Lordship, day after tomorrow, if possible, lordship, on Friday, lordship. Yes, lordship, I have taken instructions, lordship. Tomorrow.
Friday, this court will not be sitting.
Lordship, I'll verify the date and lordship.
Pardon?
I'll get instructions from my senior lordship regarding the date, lordship. Lordship may allow me.
Next week, Tuesday. That will be fine.
Lordship, I'll take instructions. Lordship, I'll inform the court master, lordship.
Inform the court master.
I'm deeply obliged, my lord.
Deeply.
May I please, your lordship? My senior, she is not feeling well, so she have left the courtroom. So kindly, your lordship, fix the matter for next date.
Where?
On 27, if possible. Your lordship, along with item number 32.
Along with
Item number 32.
item number
32.
30. So the prayer being made by Miss,
Yes.
your name,
And Kumang
learned counsel appearing on behalf of Mr. Miss
K. Devi.
R. Devi, learned counsel. Matter is the method for the thing. Item number.
May it please your lordship. When the petitioner before your lordship
Yeah.
was appointed as assistant teacher in LP school, my lord. So, my lord, that appointment letter your lordship will get at page 22.
Your lordship would be pleased to see my name is Abdullah, Abdullah, Abdullah. So what happened, my lord? At the time of provincialization, my name was recommended by the district scrutiny committee as assistant teacher of the school. However, my service was not regularized. As the service was not regularized, my lord, thereafter I came before your lordship. Your lordship passed an order dated 29/10/2021, that is at page 71. It's the order dated 29/10/2021.
Page number?
Page number starts from 72, man.
Yes.
Here, my lord, by this order, your lordship was pleased to direct the director that you see his name was recommended by the district scrutiny committee, but his service was not provincialized. That is the writ petition. So it is directed that you looked into the matter and passed the appropriate order. Here, my lord, I am reading this page 73, para 5, 73.
Yes.
As there is a recommendation by the district scrutiny committee in favor of the petitioner, we direct the Director of Elementary Education Assam to bring the recommendation made by the district scrutiny committee in favor of the petitioner to its logical end by passing a reasoned order. If the reasoned orders are in favor of the petitioner for provincialization, necessary consequential order be passed, and in the event it is against the petitioner, the same be communicated accordingly. So, my lord, hereafter the impugned order was passed. That is at page 72. So, my lord, impugned here it is said that some committee was constituted. That committee examined the matter and find that before 2011-12, my name was not in the dice court. Similar decision your lordship will get at page 76. In view of, my lord, page 76, my lord, decision. In view of the above, as the name of petitioner Abdullah was not recommended by SLSC as well as joint committee constituted by the government, since the petitioner name does not appear in the DICE data maintained by NEPA New Delhi up to year 2011-12. Meaning thereby from 2011-12, my name is there. The claim of petitioner for provincialization of service against number 1 so-and-so LP school cannot be considered, as the claim of the petitioner Abdullah is hereby rejected.
Yes, so whether
So,
SSA is a party here?
my lord,
Lordship, SSA is a necessary party here. And my lord,
So the Sarva Siksha Abhiyan is the necessary party here.
Whether included here,
Whether they have been made a party, I'll just check it up, my lord.
SSA is there. Who is appearing for SSA?
SSA, my lord, Mr. Bikram Chaudhary is there. Bikram Chaudhary is there, my lord. Mr. BB Chaudhary. Otherwise, my lord, we have received our instructions. We'll be filing an affidavit, my lord, in this matter. If your lordship checks page 76 of the main writ petition,
You have filed your affidavit.
we will file. We have got our instructions, my lord. I'm for the elementary education. And my lord, he has
You
assailed.
have not filed your affidavit till now.
Till now, we have not filed, my lord, because we'll be filing it. We have got our, my lord, instructions, my lord. Just one thing I would point out, my lord, page 76, my lord.
Then why you have not informed this court before beginning of the argument by
No, my lord, the thing is that, my lord, he started the case, started before that's why I didn't say he's
You can inform the
a
court.
little senior, so I didn't say. Otherwise, my lord, my lord, his name is not in the NUPA dais. That is the main thing. The main case is that his case was.
That I have
his-
stated before.
My lord, his case was placed before the SLSC. The SLSC scrutinized the whole thing, my lord, as well as the joint committee. When they looked at it, my lord, 2011 and 12, my lord, his name was not there. So his name was not there. Because of that, he was not in the main NUPA dais. In the NUPA dais is maintained by the SSA. So in that NUPA dais, his name is not there. So based on that, at page 76, the order has been given, saying that it's not there. So if his name was there in the NUPA dais, which is maintained by the SSA, then my lord, he would have been, his name would have been considered and he would have been provincialized. So that part, my lord, I will bring that on record, my lord, by way of an affidavit. I've got the instructions today, my lord. And my lord, I will inform the SSA council also. My lord. Probably he should have been here. I don't know why. Mr. B. Chaudhary. B. Chaudhary. From- But-
Whether you have obtained the information from the SSA.
So this is my information, my lord, from the directorate, because this
Whether the directorate had obtained the
from SSA,
then,
obviously from SSA only, my lord. But then they will have to also file their affidavit, because their affidavit also will be crucial for the proper adjudication of the case. So, but as far as we are concerned,
heard Mr. MSX, Colonel for the petitioner. We have spoken, Colonel from the none appears for the rest of the respondent. Support that we had extraction from the respondent offered it and bring on record the same by filing and affidavit in open. That's 1 week time.
well, 1 week.
That is accordingly allowed. Let's start with the method fixed.
My lord, I'm deeply obliged.
Obliged.
May I please, your lordship, these two matters regarding non-payment of area salary, lordship, this
Here
petitioner.
we are awaiting instruction. What will grant us 3 weeks time to file our.
Since when instructions are awaited,
This is the first day, man.
what's the notice was issued earlier?
Yes, not.
It was noted to issue.
Or Ghana to Colonel for the petitioner. Then Mr. B. Kotik, Colonel Council for the respondent. Elementary.
Elementary.
Party. The Kotik submits that instructions are being awaited and we respond after a week.
Let it be 3 weeks, man.
Why?
So we'll file our affidavit. Possibly affidavit will be required because it's a claim of area salary for a period, man.
Petitioner retired from service.
No, lordship,
No.
they are in service.
They are getting
are-
salary.
they are-
They are getting salary.
They are getting regular salary, but a period
Oh,
of
one
area,
period.
one period area, they are claiming area salary.
After 2 weeks. Both the methods?
Both the matters. Deeply obliged.
This case, my lord, I have filed my affidavit. I have filed my affidavit in opposition, my lord.
Where?
It's on record, my lord.
Okay.
Your lordship, kindly pass over the matter for the day, your lordship.
Why?
Your lordship, Mr. Anish Borohuya is not well, your lordship, he had to go for some checkup, your lordship, so today not possible.
When
A date may be given, my lord, in the first week of September, my lord.
as agreed by law and effect of both the parties, the matter is considered for the date. Or we. Of September.
All right. In this case, my lord, the college authority has not filed their affidavit yet, my lord. They have taken time on earlier occasions. They have not filed their affidavit yet.
Item number 37, I am for the respondent number 7. We have filed our affidavit.
College authority is the important one. That's the-
Item number 36.
My lord,
In both the cases, college authorities have to file their affidavit.
in 36, my lord, I appear for the college authorities, my lord. Now, my lord, during preparation of the affidavit, we found that, my lord, the petitioner, he has find lots of cases, my lord. So only on 12th, my lord, we have been able to lay hand the certified copy of one of the cases. Now, in this case also, my lord, virtually the prayer is same in both the cases. If your lordship says, in one case, he see, and it is a, my lord, private finance institute. In one case, he is seeking, he should be given the post of HOD in item 36, same prayer in 37 also, my lord. So, my lord, lordship will kindly grant me some time, my lord, so that I can file a detailed affidavit.
Okay.
A date may be fixed, my lord, because they are taking time on this and that place, my lord.
And it does for respondent number
My lord, in item number 36, my lord, 3456. 345.
345.
5, item number 36, my lord.
345. And you for
Lordship, I am for
37. You are
in 37 for respondent number 7.
37.
37, Lord.
And in 37, I am for 326, my lord.
Rest of the respondent.
They may appear.
So Mia, you are here for
One and two.
number
One and
1 and 2. So Mia for respondent number 1 and 2. Mr. Does granted for the respondent number 4, 5 sub that he may be granted some time to file a detailed evidence. Where is accordingly allowed with the matter. After
3 weeks time, my lord, lots of cases are there, my lord.
after 3 weeks. Okay. We will fix it. In item number 37. He does counsel for the respondent. Here your respondent number
My lord, in item number, this
37.
3456,
3, 4, 5, 6.
private respondent.
Then Mr.
KJ, on behalf of
Learned counsel referring on behalf of the
SCK, Standing Council, Assam University.
Standing counsel for the respondent number
Respondent number 7, Lord.
7. Then UGC. Then Mr. Muya for
One
respondent
and two.
number
1 and 2.
1 and 2. 1 and 2. Mr. Das learned counsel for the respondent number to submit that in the granted 3 weeks time to file detailed affidavit. Where is accordingly allowed. That's the matter on.
May I please, your lordship? My lord, petitioner, your lordship is this assistant school teacher, my lord. And random pickup was done by the police authority, my lord, in the name of land grabbing. Accordingly, he was arrested and he was enlarged on bail, my lord. But police, after due investigation, my lord, find a closure report against the petitioner. Petitioner intimated to the authority, but in the name of that, my lord, still departmental proceeding is going on against him. Lordship, kindly have a look at page, my lord.
The criminal proceedings.
The final report, lordship, kindly have a look at page. Operative part, my lord, of the charge sheet, my lord, lordship will see at page. Lordship will see the page 45, my lord. Further, I beg to report that during the course of investigation, there is no evidence are found against the arrested person, Sri Kandarpo Deka, son of so and so, that is the me, my lord. Last page of the final report. Thereafter, my lord,
page 46, my lord, in the name of that, my lord, police case number 98, my lord, I have been issued show cause, my lord, departmental proceeding. Thereafter, my lord, another show cause was issued at page 47. That I immediately, my lord, intimated to the authority, my lord. Authority by writing a letter, my lord, at page 51. Even though, my lord, the departmental proceeding is going on against. That is my case. And
Now, what is your prayer here?
prayer, my lord, to set aside and quash the departmental proceeding basing on the police report. That your lordship will see page 40.
Sir, Kaushik, you are appearing here?
Well,
You have filed your affidavit here?
No,
not
my lord,
yet.
no affidavit has been filed.
But you give me 2 weeks time, my lord. 2 weeks time, my lord, to file my affidavit.
Once, my lord.
Otherwise, the petitioner is already reinstated, my lord.
That is not, my lord. My departmental proceeding, my lord, that may be stayed, my lord. Let them take time. I have no objection. And basing on that
So
FIR,
the
my
interim
lord,
order in the first day was refused, my lord.
not refused. Not refused. Don't say utter like the word refused.
Well, you address to the court, don't utter to me.
Why is saying, my lord?
Well,
the
this
refused?
is well, something should not be encouraged, my lord. Well, he should address the court, not me, my lord.
I'm addressing to the court only. No point of time
And
it was
we
refused,
learned
my
it from our senior, my lord.
Lordship kindly
How
have
they
a look,
behave in
my
the
lord.
court.
That's why, my lord, wrong submission cannot be made, my lord. That it was refused. Lordship kindly have a look.
There is way for objecting the same.
My lord, even though, my lord,
Uh,
my lord, I did not say badly, my lord. I said, my lord, not to say like this. The wrong submission.
no, that amounts to threatening him.
I'm not threatening, my lord. Why shall I
Right.
threaten, my lord? He is not my personally, my lord. I'm just a lawyer, my lord. Why shall I threaten? Lordship, can
At
you
this
see
stage,
the
my lord will
first order?
allow me 2 weeks time to file my affidavit.
My prayer is that, my lord, further
In
proceeding is.
respect of interim care also notice was issued.
Yes, my lord.
Let him file a reply.
Great.
My lord, that's why
Highly obliged.
I got, my lord, it was refused. It was not refused at all.
Pardon?
My interim prayer was not refused at all.
Refuse, yes. Notice was issued.
Yes,
Please
my
proceed.
lord. At the most, he can say, my lord, interim prayer is not to be considered today. Refused what should not be uttered, my lord. Wrong submission, it is nothing but misleading the court, my lord. At the first impression, your lordship will think it has been refused. Then again I came.
Hard Sonia Garnet, Formia Garnet, so hard. Limited department. But Kaushik Garnet, department. 2 weeks time.
Great, my lord.
File is affidavit. There is recording. Yes, after 2 weeks.
My lord, the date may be fixed, my lord. On that day, my lord, interim prayer will be considered, my lord. On that day, lordship will an observation be given, my lord.
So let him respond.
My lord, something has to say again. He will say it was refused. Or
No,
another.
It is there in the order itself.
No, lordship can give a small submission, my lord.
Well, my submission was on the first day. It was not. It was refused. It was, my lord. It is on record, my lord. Now that everything is on record, my lord. He prayed it very hard, and it was refused by the court, saying that we'll consider it on the next day after the instruction is received. That is, my lord. It's everything is record, my lord, in the live streaming.
Let him file a
Lordship can
Such
say,
kind
my
of
lord, on
should
that
not
day,
be
my lord, we
appreciated.
consider the interim prayer.
or filing of the application by care of the
Awesome.
Items 53 and 57. Kindly see the last order, ma'am. Good evening.
Yes.
Kindly see the last order. There is almost a direction to complete the process by 20 to today, madam.
Mr. Verma, any instruction is available?
Some time is required, my lord. At least 10 days time may be granted.
Earlier, my lord, it was said the instruction was received.
See, this order was passed on 27/6/2025,
Yes, ma'am.
taking the matter today.
Yes, ma'am.
So why the instruction are not available?
This instruction is not coming and my lord, moreover, in the
Whether-
notice also, it is
Whether you have
reflected.
communicated it to the respondent authority.
In earlier occasion, D. Musahari appeared, my lord, in this matter.
The problem.
My lord, 10 days may be granted so that I communicate matter.
Or nobody starting meeting or not, the respondent secretary or not submits that instructions are not available. And it does so the matter after 10 days, where is accordingly allowed is the matter after fix it.
2nd of September. 2nd September. My lord, it was an earlier occasion, my lord. The respondent said that proposal was received, my lord. They received the proposal. So, my lord, matter is almost complete, my lord.
Regarding the development status, yes.
Almost the
Instruction is
proposal were received from the district authority. So what are remains, my lord? So my humble submission, so on the basis of that instruction, my lord, 28/20/25 was fixed. Right. By this time it will be a complete, process will be completed. But today they are saying again, my lord, instruction is not,
So we are fixing it
my lord.
2nd of not a bit for the matter after one.
Order hasn't been complied yet, my lord. Oh,
In this regard, Your Lordship, the office has already issued one letter to MD SSA requesting for submission of DICE data of TMPJME school up to the year of 2022 to 2023. Write the office letter number so and so. The hearing report will be finalized immediately after receipt of the said data. Letter was issued to SSA, Your Lordship, for submitting of the DICE data.
Page 6 I think the compliance order for this part. Where is the
DICE data is not, already hearing was completed, but DICE data was very much required in this matter, Your Lordship. So, Your Lordship, it was awaited for the part of the SSA. Already,
this
letter was already issued to SSA, Your Lordship.
order was passed on 29/5/2025. Since then, what you have did? You have written this letter only on 19th of August 2025.
No, 19 of. Up to date
In between
instruction.
what you have did?
Here, Your Lordship, in this matter, Your Lordship, SMT 60 is appearing. I am appearing on behalf of him, Your Lordship. And this is the fresh instruction I am received. So kindly grant us 2 weeks' time, Your Lordship.
Pardon, sir, Principal, pardon. Appearing for the response. It is the coordinate letter dated 19th of August. Dated by the director elected the sending of that the officer already sent letter to the side of SSA requesting for submission trial version of MJM the year and the hearing reports will be finalized after receipt of the said data and requested to place the method after hearing place the method of forwarding the
Pleasure.
Deeply obliged.
the letter for the protocol the part the method part
May I please? Lord, in this matter, my lord, respondent 4 and 5 have filed affidavit, my lord. But the departmental affidavit has not yet been filed, my lord. It is required, my lord. They have challenged the appointment of the respondent number 5, my lord. Department has taken time to file the affidavit, my lord.
part is that
K. Uddin, my lord.
learned from report and also heard the
M. Hussain, my lord.
M.
M. Hussain,
learned council appearing for
respondent number 4.
respondent number
4.
4. Other dates to the respondent number 1, 3, and 5. Whether the service completed or not?
Service complete, they are the, my lord, the Director of Elementary Education and District Elementary Education. Service representing by the Elementary Education Standing Council. Service is complete.
The learned council could have pointed out that the department respondent in elementary education department have not filed their affidavit and ordered to adjudicate the dispute. Adjudicate the dispute. The departmental affidavit is very much.
Look, I'm praying for 3 weeks time.
You are very
My lord, yes.
letter of public 1 with 3
1, 2, and 3.
price for granting
3 weeks time.
price type there is a allowed after 3 weeks.
My lord, the date.
Obliged.
Obliged.
Beg your lordship, my lord. My lord, it is one of the glaring examples of how injustice has been carried out to me, my lord. I retired as an peon, my lord, from the Khadi and Village Industry Board in, my lord, 2020, 31st July 2020, my lord. And my lord, I just want to take your lordship to Annexure A, page 9. The operative portion is, my lord, at page number 11. I'm just reading out the relevant portion for lordship's kind convenience. Page number 11, my lord. This court would further like to observe that taking into account that the petitioner has already retired, the respondent authorities, more particularly respondent number 1, 2, and 3, are to take steps for initiation and completion of the said disciplinary proceeding within a period of 6 months from date of instant order with the above petition stands disposed of. Thereafter, my lord, disciplinary proceeding had already been completed, my lord. I have, until now, my lord, I have not been given pension area and other benefits, my lord.
related to my pension, my lord.
Service completed or not?
My lord,
Service completed?
completed, my lord,
When?
completed, my lord.
When?
They have been deliberately delaying this matter, my lord. Why? Because
Deliberate.
the big shot is involved. Dr. Kamalakanta College, Chairman, the Assam Khadi Village Industry Board is there, my lord. And I'm just a peon, my lord. I got no say, my lord. I'm at the lowest strata of the service, my lord. My voice is not heard, my lord. I am only before the Lordship's Majesty's court, my lord, to give me justice, my lord. They show such a scant regard for the order of the Honorable Guwahati High Court, my lord. They flout the order of the Honorable Guwahati High Court in such a manner, my lord. So many content cases have been pending in the Guwahati High Court, my lord.
You go to the record and you tell me whether service was effected upon the respondent or not.
My lord, my lord.
The record.
My lord, my name should be recorded as S.S. Rahman. I am appearing on behalf of my triple S Rahman.
Contempt for non-compliance of the order dated 22/2/23, my lord, page 10.
And thus they were appearing for?
That's for sole respondent.
Sole
Your Lordship.
respondent.
The judgment is still pending, Your Lordship.
Pardon?
The matter is still pending before the London Division Bench, Your Lordship.
Division bench.
Yes, Your Lordship. And then you stay at the Division Bench order, Your Lordship. The
Whether
appeal was
any
filed by
date
this.
is fixed there?
No, last listed on the 7th of March 2025, Your Lord. But the
Yeah,
order is not
when
uploaded. 7th of March 2025, last listed, Your Lord.
Okay, we'll list the matter after vacation.
Yes, Your Lord.
That agreed by not that advocate to both the parties. Immediately after reopening the vacation.
Oblige, Your Lordship.
Color number 5.
Finally, page number 24, Lordship. The elegant portion of the order concerned, Lordship.
Service completed here?
Yes, Lordship. In fact, on the last occasion, learned counsel for the concerned department has said their instruction is awaited.
Who is appearing for department?
Vakalatnama is yet to be filed, Your Lordship. So kindly grant us some time, Your Lordship, to file our Vakalatnama.
Long pending, Lordship, which way back service was completed.
Why Ukalatama is necessary? For representing the department.
53rd. Yes, Your Lordship.
Then?
It was allotted, Your Lordship. So, Your Lordship, I am not elementary education. I'm
Maybe, but
but,
why you are then submitting that?
SNP 60 is not here, Your Lordship. So, on behalf of him, I am submitting that Vakalatnama will be filed shortly, Your Lordship. So, kindly grant us any date, Your Lordship, apart from today.
NZ Chaudhary.
Either. This the matter on of it.
I'm deeply obliged.
Beg your lordship. My lord, actually, this matter has been conducted by my twin brother, my lord. He has suffered heart attack, my lord, and he has undergone bypass surgery, my lord. So this matter will be listed in the last part of September, my lord. If the lordship places, my lord.
Third, order SSA Rama Karnataka.
My lord.
You have filed Ugalatama here.
My lord.
You have
I-
filed
I'm-
Ugalatama here.
No, my lord, under his instruction, I have been appearing, my lord.
Appearing under instruction of the chief justice from Karnataka King of and if press for listening the matter in the last part of the paper, there is accordingly allowed as the matter. Last week of September.
My lord. Obliged, my lord. Highly obliged.
May I please your lordship?
Yes.
My lord, this is an application for clarification of an order passed by your lordship on a civil division, my lord. And civil division was filed against an order of the Industrial Tribunal Guwahati on a application filed by us on the point of jurisdiction. And while hearing the matter, my lord, the learned counsel for the other side, he he produced one notification, my lord. And he accepted that there is no jurisdiction, and on that point, the impugn order was set aside. So up to this, it is all we have no grievance, my lord. Only in the order, my lord, may I read the order, my lord.
No, you tell me what is your grievance?
My grievance is that while the other learned senior counsel for the other side, he produced a notification, my lord, that this is not the forum. The forum is actually the Secretary, Labor and Welfare Department. So our submission is that, my lord, that notification is not applicable to us. So that instruction was given to our counsel, the earlier counsel, and he just mentioned that no objection to the your lordship must have asked whether you have any objection, and he said no objection, my lord. So only this clarification is required, that the no objection that was mentioned, my lord, that is for the existence of the instruction notification, my lord, not on the point of jurisdiction. That little clarification we require, my lord. Otherwise, again, it will be misinterpreted that we have accepted we have given consent to that jurisdiction as per the notification. This notification is not applicable to the bank, my lord. Bank is regulated by the Industrial Dispute Banking and Insurance Companies Act.
That counsel entered appearance on behalf on instruction from the bank.
My lord.
On instruction from the bank, he entered appearance.
No, he was given instruction, my lord.
Yes.
But that was not properly conveyed, my lord. That time we do not whether it was conveyed or that was perhaps not conveyed, my lord.
So we have given him time.
My lord.
He is also time to obtain instruction.
My lord.
After, on the next day, he obtained instruction and apprised this court that the bank has no objection in the event
My
of.
lord, that instruction was not properly conveyed, my lord.
No.
And
that argument cannot be allowed to pass before the court.
And this no objection will be misinterpreted, my lord. Again, it will go to another wrong forum, my lord. Again, one round of dispute already over in the Industrial Tribunal. Now again they are appearing before the secretary. So that is also will be a wrong forum, my lord.
That is as per notification or produced before the court.
No, that is why what we are submitting, my lord, that this notification is.
Tomorrow, today you are appearing, tomorrow another counsel will appear and submits that no, earlier counsel was has not conveyed the information.
No, I am not pointing any.
It's a procedure.
No, my lord, I am not pointing anything wrong against the counsel, my lord.
Then
only that instruction was.
Why should we disbelieve the counsel?
Only perhaps it was not properly conveyed or this.
What clarification is required here?
That no objection may not be taken as giving a consent, my lord.
Then
No objection.
How it has.
No objection is only on the existence of the notification, my lord. That is our
my instruction, my lord, that the no objection that the council said was on the existence of the notification, not on the point of jurisdiction. my lord. Only this may be recorded and your lordship may decide.
No. The council was authorized to enter appearance and he accordingly appeared and he submitted that he has received the instruction and the instruction is that the bank has no objection in the event of causing the proceeding before the labor court and referring the matter to the commissioner.
My lord, this notification was passed under the industrial employment standing orders, my lord, which is applicable to industrial establishments employing workmen, my lord. The respondent is not a workman, my lord, and ours is a private sector banking company, my lord, which is governed by the Industrial Dispute Banking and Insurance Companies Act 1949. No, our grievance is that only it may again go to another wrong forum, my lord. It will more litigation, my lord.
No, Mr. Council cannot approve it and reprove it at the same point of time. The order passed by this court was a consent order. If you want to challenge the order of this court, you go to the Supreme Court, file SLP there.
And my lord, another that is not applicable here, my lord, is but consent of parties also do not give jurisdiction where there is none, my lord. On that point, there is decision, but this is not applicable now, my lord. Even given a wrong consent, my lord, it will not create a jurisdiction, my lord.
We will issue notice. But you have to take a risk that it may entail heavy cost. Pardon me, sir, your good name?
And Islam, my lord.
Learned counsel for the applicant. The interlocutory application is deferred under section 152, with section 151 for modification and or clarification of the order dated 23rd 5 passed by this court in Cherokee Ayuk 8935. Issue notice to the opposite party returnable in 4 weeks that will be taken by Mr. ADN. This after 4 weeks.
Your Lords, item 58. Your Lords, am I audible?
This IH for what purpose?
My lord, this happened during the pendency of the main writ petition before this court. The department issued a show cause notice, Lordship. So it's amounting to parallel proceeding with parallel proceeding during the pendency of the main writ petition. So against that show cause notice, we have come before this court by filing of this IL, Lordship. So on the last of the instruction was served.
Instruction available.
I'm appearing for the SSA. Instruction was supposed to be taken by elementary department. Lordship.
Pardon me, sir. Applicant, Mr. B. Chaudhary for the respondent
For respondent number 3, Lordship.
for respondent number 3. None appears for respondent. It appears the order dated 30th that the learned computer respondent has to obtain instruction, but the council didn't accept how the this the method of the
Question. Kindly next week if possible, and my lord.
third 1 week.
Okay, Lord.
Please, Your Lordship. My lord, I filed an IA for implement of the pension directive, my lord.
I have no objection, Your Lord. Implement.
Third F M N Mullah learned A F N Mullah learned F N teacher. Third applicant referred by the applicant in the content or numbered proposed order 6.5 that's necessary for the who is the concept or number 2
Row number 2, my lord, director of pension, my lord.
director the learned for the applicant concept or number because the CFS director of pension fund and he is required to be implemented as concept number 3. So in the concept case for 6.5 the sum is more big. Then they take the part allowed. They discuss the director of pension implemented as concept number in concept case for in terms of order passed in this IA, the council for the file amended for cycle in contempt case number 615 of 2024 in a period of 1 week from today.
Deeply obliged.
Number 58.
Please, Your Lords. Your Lords, am I audible? Your Lords, I am for respondent number 1, Guwahati Construction. The company is under liquidation, Your Lords. Your Lords, however, the appellants, without disclosing the fact that it is under liquidation and that no proceedings can be initiated against a company which is under liquidation, has filed this appeal, Your Lords. Your Lords, kindly have page number 35 of my application.
Lordship, we are yet to file our response. Lordship, may grant us 3 weeks time to file response to this
Lords,
application.
let me complete my
Because
submission.
it has come for the first time.
Yes, Lords, let me just complete my submission. Your Lords, kindly have page number 35 for a moment.
Notice was already the year
Pardon?
2024.
Lordship?
Notice was issued in the year 2024.
No, in the IA that has been filed. That IA has been came for the first time.
IA number
2022, Your Lords.
you are appearing for
For Union of India, for the railways, Lordship.
railway.
This is our land. Someone built
Your
flat
Lord,
landship and sold this to other person, where
Yep.
which the bank taking loan from the bank.
Your
The
Lord,
land as on today stands in our name, in the name of railway.
no, Your Lords, their suit was dismissed, Your Lords, by the.
Notice go at this, is this?
Yes, Lordship.
Let
First
him
notice
file
has to go.
Please, Your Lords, actually the issue is, Your Lords, the company is under liquidation and there is a status quo order because of which the liquidation proceedings are stayed, Your Lords. The company is under liquidation, Your Lords, on by order dated 10th February 23, which is Annexure 4, Your Lords. Because of a status quo order, now the liquidation is under.
Mr. Council,
Yes, Your Lord.
you see, this matter pertains to bench one. Bench one is being taken up by court number 8.
Please,
It
Your Lords.
should have been listed before that court, not
Your
before.
Lords, if I believe, Your Lords, that bench had recused earlier. It was no mention before me. Order was passed, Your Lords, in that on 13th of August, Your Lords.
Okay. Okay.
Hence, Your Lords, we are before you.
Okay. Well, let Mr. Chakraborty come with his response.
Lordship, exactly.
Your Lords, a short time because the liquidation proceedings
Yes,
are
short time. Okay.
in limbo. Please, Your
Mr. Your good name, please.
Nirmal Goenka, Your Lords.
Learned counsel for the applicant. And also heard Mr. Chakraborty, learned counsel for the standing counsel for the
For one only, Lordship.
respondent number, opposite
For
party
one.
number 1.
One.
This interlocutory application under section 151 of the Code of Civil Procedure be heard by the applicant. To pass appropriate order, thereby permitting the applicant, truck liquidator of MS Guwahati Construction Private Limited, or struck corporate debtor to assign of assets of MS Guwahati Construction Private Limited, struck corporate debtor as not readily realizable assets on as is where is basis with all the litigation and encumbrances on the state assets and struck or pass such order or other order as deemed fit and proper by this court. Let notice be issued to the responsible returnable in
3 weeks.
2 weeks.
3 weeks we have to file our, because we have to go for vetting and all.
Your Lords, 2 weeks, Your Lords, because the company is under liquidation since 23, and because of this order now, the liquidation proceedings are stalled. They did not disclose that the company is under liquidation and obtained a stay order, Your Lord.
Registered post which carry in also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 1 in the entered application. However, extra requisite copy of the application will be furnished to him list the matter after 3 weeks. In the meantime, Mr. Chakraborty learned standing counsel for the respondent number 1 may file his response.
Oblige, Your Lords.
Next.